day today. May fix after 1 week.
47.
47, Lord. I am for the respondent.
The request of for the respondent, Mr. D. Kolita, matter stands referred to be listed after
1 week.
1 week.
So 2 week, Lord.
And
2
for the
weeks. Yes.
Obliged, Lord.
That is a lordship. Okay, I beg to mention item number 30. Lordship, with the consent of the other side, lordship, 2 weeks time may be granted, lordship, to file our affidavit.
Date may be fixed.
Item 30 also adjourned at the request of counsel for the respondents. Consent of the counsel for petitioner obtained. Matter be listed after 2 weeks on a date to be fixed by the registrar. Item 47 or to be for the consent of the other.
Item number 31, Malad, he is for the. Malad, in this case, they have already terminated our contract, Malad. And the termination is specifically in the arbitration clause, Malad. A short date may be fixed.
After 2 weeks, any date, Malad.
A short date for this matter.
Item 31, same prayer. Be listed after 2 weeks. Date to be fixed by the registrar. Yes.
Deeply.
May please your lordship, also recollection, item number 90. Lordship, with the consent of the other side, I refer your lordship to kindly adjourn the matter for the
Item 9.
item number 9.
Item 9 adjourned at the request of counsel court.
Lordship,
On whose behalf are you making a matter?
P. Mahanta.
P. Mahanta, petitioner, respondent, on behalf of the respondent.
Appointment of an arbitrator. We have given notice, we are objected to the panel of railway officers. But arbitration is
Hard company parties to look at it. Seems the respondents are represented. And A. Gupta on behalf of all respondents. Since the respondents are represented, because of the extra copies be furnished within a period of 1 week.
Lordship, by order, by page 57, they have already started the process of arbitration. Therefore, it may be kept in abeyance.
You are praying for what?
Appointment of an arbitrator.
Without your consent, they have how they have proceeded.
Yes, Lordship.
Huh?
Yes, that is my case.
Not in that case, they should have applied for termination of the mandate because arbitrator has already entered into reference.
Where is the order of appointment?
But Lordship, page 57.
Page 50 is the first order, my lord, passed by the.
See, one of you submit. Don't
My lord.
make cross submittal together. 57 is what? Notice.
Yes, notice to for date, first date.
Where is the order appointing the arbitrator?
Yes, Lordship, page 49, 50. Page 49 and 50.
Where is this letter referred here? Page 48. Page 48,
Yes, it was the panel given to us.
reference. In the reference, there is a letter written by you, 4/11/24.
No, no, that is the notice, Lordship.
Where is
Notice
it?
at page 40. Pursuant to the court's order, at page 40, we have that is notice invoking arbitration. Then they gave the panel of arbitrators from their own department, retired office. Then this at page 46, they sought for a waiver, which we have not consented. At page 46, undertaking is at page 47.
You have invited them to appoint an arbitrator.
No, Lordship, we have objected to it. That's it.
Page number 45, para 9.
Lordship,
Page 45, para 9. You asked them to appoint. They have appointed.
no, Lordship, they have given the panel. We objected to the panel.
Why don't you see the notice? You did not name the arbitrator.
Yes.
You asked them to appoint an arbitrator. They appointed from their panel.
No, Lordship, we have objected to
You must first give a name that we want to appoint so and so as an arbitrator, consent to it. In your notice, it is not there. At this stage notice, you file your objection.
My lord, there they can file the objection to the tribunal also.
Not there. You
No.
are aware of the law.
My lord. Yes, my lord.
Then without waiver, how can you proceed for a unilateral appointment of an arbitrator?
Because my lord, the prayer which they may have made at page 45, that had they made the prayer for appointment as per the provisions of the Arbitration Act. Now
So
it's
file your objections here.
my lord.
Let them file objections. Your facts are very sketchy. You may have consented to it. You may have waived your right.
They sought for specific waiver undertaking. We have objected to it. Lordship.
Let us see what comes.
Deeply objected.
Wait, please, Lord. Lordship, have a look at last order date in 9/4/25. Here,
Yes.
here, my lord,
compliance order.
yes, I've talked with the authorities today also, my lord. What had happened is, my lord, moment, my lord, on 8/4/2019, the earlier, my lord, suspension order was interfered with. He was arrested again on 9/5, exactly after 1 month. When the process for reinstatement was on, Lordship may kindly see page 4 of the contempt. Page 4, para 6.
What is the direction of the court?
Direction, my lord, was that, my lord, so far as the suspension order was concerned, my lord, that was interfered with. Page 11, para 10.
Yeah.
Now, Lordship will see page 4, para 6. Just 1 or 2 lines, my lord. That is stated and submitted herein that despite receipt of the order dated 8/4/2019 passed in so and so, whereby the suspension order dated so and so, graduate corriendum was set aside, the petitioner had neither reinstated in service nor the suspension allowance were paid till date. In the meanwhile, all of a sudden, on so and so, petitioner was arrested by so and so. So, when 9/5/2019, again he went on deemed suspension because he was behind the bars for more than 48 hours. So, my lord, I've already, my lord, talked to the authorities that they will have to, my lord, reinstate the petitioner for this period from 8/4 to at least 9/5. So let it be, my lord, at least after 1 week.
8/4/2019.
Yes, still 9/5/2019. They said that, my lord, since it was under process in the meantime, he was again arrested within a month, my lord. So they could not reinstate him. But, my lord, since there is the order, at least this period will have to be to at least to comply with the court's order, my lord.
To do it.
Yes, ma'am. Let it be, my lord, after 10 days, my lord.
The
He has
direction
already
of the
retired,
court is that you are to produce the compliance order today.
my lord. My lord, I've talked with them, my lord. They are
The
doing.
order of the court.
I understand, my lord. Yeah, in fact, I appear.
Is it?
And in the meantime, he has already retired on, my lord, 30/10/2020.
Don't know about that. When there are orders of the court, please comply with it or seek an extension of time,
My lord,
go for modification. Don't
I
allow
understand.
orders of the court to sit like this.
Lord, and 10 days, my lord, I will place the order.
10 days, you do it by Friday. They are giving you last chance.
On Monday in that case, my lord.
No, Friday.
My lord,
There's already enough time given.
yes, yes. I will come up with the instruction, my lord, the compliance. Let it be on
What
Friday.
instructions, if there is a direction to comply, you comply with it.
My lord,
Or you seek an,
extension, my lord.
you seek applications for modification of this order.
Lordship, let it be on Friday, my lord.
Yes, list on Friday. Enabling Mr. P. Goyal and an additional learned counsel appearing for the respondents
My lord.
to complete his instructions in respect of the orders of reinstatement to have required to be passed in favor of the writ petition. List on Friday.
My lord. Obliged, my lord.
Friday 30.
30th. my lord. Right. Okay. Last order, Lord.
Complied, not complied.
Lordship, this is not contempt law.
Huh?
Not contempt law.
Okay. Has become infractuous.
They by 10/11 order dated 10/11/2020, he was asked how much he can.
By the last order dated 26/07/2021, counsel appearing for the petitioner submitted before the court that the writ petition may have become infractuous. He prayed for some time to complete the instructions. Thereafter, the matter has been listed to the counsel for the petitioner is also not present. While Mr. Justice Roy, then a CPC appealed this matter.
No,
What was the prayer here?
Your Lordship, on 10/11/2020, there was a direction to the petitioner to provide the information that how much he was willing to voluntarily want to pay his wife maintenance amount. 10/11/2020 law.
That amount has been deducted.
That instruction, and
Can you not get it during the course of the day?
that I will. that I can do.
Then we'll take it up in the second half.
Lordship,
You can include the counsel for petitioner also.
Lord.
It is lordship. First on this matter, I'm praying some time to file our reply, lordship.
If it's so and so, counsel for the petitioner renews our prayer for further time to file rejoinder affidavit. Prayer made is not objected to by the respondent, next accordingly after 3 weeks.
On the last, on the last occasion, we asked for the copy of the affidavit in opposition. Kindly, they may be provided.
You are making a prayer for filing rejoinder without the copy of the affidavit.
Yes, lordship.
Why?
Lordship, my prayer is to serve the copy to ask the affidavit in opposition, because on the last occasion, we have asked for, we have not received yet, lordship.
Last occasion, the prayer recorded is you prayed for time.
Yes, lordship, that has not been reflected here, lordship, but we have been recently engaged. That is why we don't have the copy.
Yes, respondent,
Why does-
do you have a copy of the affidavit?
Lordship, I will send it later. Oh, no, no.
Petitioner, respondent, which respondent is it? Which
Lordship,
respondent?
Lordship, this is the Corporation Department matter. Lordship, the affidavit has already been filed and copy has served to the earlier council. They are the newly, they will serve copy.
Since,
Copy of the affidavit,
since it is stated at the bar that the copy of the affidavit by the respondent cooperation department was already served at the time of filing, but perhaps to the earlier set of counsel. And since there is a new set of counsel, the cooperation department will furnish an extra copy to the present set of counsel within
of
2
like-
working days.
of like-
The petitioner had to submit the GIS certificate, Lordship. He has not been able to submit the GIS certificate, Lordship. So, Lordship, we have written to all the districts for onward submission of the GIS. He was working in different places, Lordship. So this is the up-to-date instruction. We are processing the matter, Lordship. All the other arrear salary has been paid. Everything has been paid. Only remaining is the GIS.
Your Lordship, we will file, submit the GS certificate today.
Today,
Yes, today I will try.
counsel for the respondent FSR submits that all other arrear payments payable to the petitioner has been released. The petitioner except the claims under GIS. So this could not be released as the petitioner did not submit the GIS subscription certificate. So once it is submitted, then necessary process for release of the amount standing the credit of the petition. Amount found to be payable to the requested. So counsel for the petitioner submits that they will submit the GIS certificate when
Today, today
before the office.
we have contacted, they have said that they will submit.
Submits that the GIS certificate will be submitted within 2 days. Accordingly, just after 2 weeks.
Deeply obliged. Mr. Lordship. Lordship, the matter is regarding the reinstatement of service. According to the last law, Lordship, we are asked to take steps. Then we had taken it, but the Lordship service report is being awaited.
As per office note dated 30/5. When did you take steps? Yes. See, that fresh step was directed has not been taken by the petitioner. Till the petitioner must submit that fresh step has been taken on. Taken. You have the date or you don't? When did you, why did you say you've taken fresh steps?
When it is
Office to re-verify. View of the submission made by the petitioner and make necessary endorsement. Please again after the voice.
May I please, Your Lordship?
Yeah.
Your Lordship, respondent number 6 and 7 subsequently added, Your Lordship. And as per the office order dated 20th May 25, Your Lordship, some mistakes is there in the address of the 6 and 7, Your Lordship. That need to be Kamrup Metro, Your Lordship.
This order dated
20th 5, Your Lordship, 25, Your Lordship.
Lozima order.
Was in order, Lordship. We file appropriate application for amendment of the first line, Your Lordship.
Let me inquire to the order. Lordship,
Per order dated 2005/2025.
Lordship. This matter become influx as my lord, because this honorable court has already directed the department to complete the process, and we have already appointed the.
That was much earlier, Your Lordship.
Yes.
Still, there's an ambiguity, Your Lordship.
No,
Still,
Lordship.
still, Your Lordship, if Your Lordship kindly come to the RTI, Your Lordship, because this matter pertains to, Your Lordship, we are challenging here the appointment order of the candidate, Your Lordship, MBI Inspector, Your Lordship, for the post of.
The IA Lordship, IA order, last page, my lord.
SI is filed by whom?
APSC, my lord. And this honorable court has directed us to go for lordship, and already we have appointed them, and the final order has already been passed in the writ petition.
We are challenging the appointment order also, Your Lordship. Filing an affidavit, Your Lordship, additional affidavit, Your Lordship.
This writ petition was filed by somebody else.
Somebody else.
Was the candidate, Your Lordship.
Appearing for MBI.
MBI, Your Lordship, under EWS category, Your Lordship.
Selection list has not been upheld.
Lordship,
Selection list has not been upheld as such.
selection list has been upheld, my lord. And the petitioner, there are 6 petitioner in the earlier writ petition.
Were declared to be selected.
Selected, yes. And, that's why we have earlier, by an IA order, we have appointed 22 numbers MBI. And after that, another 4 we have already appointed.
Therefore,
The select list has
they
been
are
upheld.
challenging this selection list.
Selection list, yes.
Ah.
This selection, this honorable court has directed you go for the appointment.
No, maybe, but that does
Yeah,
not
that's-
mean that the selection list has been upheld.
No, Lordship, what happened?
Hmm.
That 4 petitioner appeared before this honorable court.
6 petitions.
6 petitioners, Lordship, challenging their selection of candidature by the APS. Thereafter, all they were permitted to appear in the screening test. Out of 6, 4 qualified for the interview, Lordship. And 4 post has been kept reserved as per order of the honorable court. As per order of this Lordship, before your Lordship, all were appointed. So select list has been exhausted.
Your Lordship, by additional affidavit, Your Lordship, we bring on record that the person has been appointed only challenge that part also, Your Lordship. And for that reason, Your Lordship, the EWS category, who the other person who selected under EWS category has been impeded, Your Lordship, with the permission of this honorable court, Your Lordship. And if Your Lordship kindly come to 38 page number, Your Lordship, that is the RTI reply, Your Lordship. Still, the selection process is not fair, Your Lordship, under ambiguity, Your Lordship. For that, Your Lordship, we have preferred this repetition, Your Lordship. As per my calculation, I am the highest mark holder, Your Lordship.
Where are the respondents who you have arrayed? Have you arrayed the respondents?
Yes, yes,
Selected?
Lordship. Yes, Lordship. After it impeded subsequently, Your Lordship, after finding a IA, Your Lordship. The selected candidate has been impeded, Your Lordship. As respondent number 6 and 7, Your Lordship.
This writ petition was not connected.
It
No,
was
sir,
earlier
it-
connected, but they said it was different. So this
This is
honorable
different, Your Lordship.
Why?
Because, Your Lordship, I'm not on that, Your Lordship, because there are some diploma holder and some bachelor in engineering. Their dispute is on that, Your Lordship. My dispute is not on that, Your Lordship. My dispute is that, Your Lordship, I have applied under EWS category for that post, Your
It
Lordship.
could have been examined by the court, the same matter,
Your Lordship, if Your Lordship kindly come to 38, Your Lordship.
38.
Yes, Lordship, the RTI reply, Your Lordship, which we sought for, Your Lordship.
We are not on that. What I am saying is, when the matter was examined by the
Yeah.
court,
Lordship.
this should also have been heard.
No, Your Lordship, that part has been detached, Your Lordship. At that time, I have not preferred this repetition. Subsequently, I have preferred this repetition, Your
Is
Lordship.
there any order segregating both the matters?
No, Lordship, it is complete another aspect, Your Lordship. Because I am not on even that, Your Lordship. I'm
The select list is under challenge
put under challenge, Your Lordship.
on whatever grounds you may have.
Your Lordship,
It was also under challenge in this writ petition.
in that repetition,
That writ petition did not interfere with the select list except for these 4 persons.
Lordship. That was the 6th petitioners, Your Lordship. I'm not from that.
Not required to examine the select list on every petitioner's
No,
case.
it's not with due respect, Lordship. It is,
Then
yes, Lordship.
ground.
No, it, Lordship, but
That-
if Your Lordship kindly see, for that reason, Your Lordship, I would like to drag the attention of this honorable court, Your Lordship, at page number 38, Your Lordship. Because that is another aspect, Your Lordship. My case is something based on another footing, Your Lordship. Because still, Your Lordship, yes, seeing Your Lordship, 38, Your Lordship. If Your Lordship kindly come to page number 38, Your Lordship. My dispute is, Your Lordship, between this, that EWS candidates, Your Lordship. Not between those 6 petitioners, Your Lordship.
What do they say in their affidavit?
Lordship, in the IA, I have filed affidavit, but in the writ petition, this petition,
IA for what? Yeah.
IA, they have filed one IA, Lordship.
For?
One push, the,
Most thing, thank you, Lordship, in the disposal of the writ petition.
it's
Lordship.
I number 3130/2024, my lord. The prayer portion is page 8, page 8.
But they say their 24 7 filled up.
Yes, my lord.
Please, your Lordship, all the posts has been filled up, Lordship, I got to know that because they have preferred, the I got to know about that, your Lordship, but the thing is that, your Lordship, the EWS candidate, your Lordship, another seat selection list, your Lordship, they are not even reached the cut-off marks, your Lordship.
How do you know about this information?
Yes, Lordship,
Page,
we have filed an RTI, your Lordship,
page number?
38, your Lordship.
Okay.
Lordship, when it comes to serial number 1, that is marks obtained by me, the petitioner, your Lordship. That is 124.25, your Lordship. Again, if your Lordship kindly see, we obtain, your Lordship, highest marks obtained in screening test by the EWS category, your Lordship. That is 102.50, your Lordship. Now, if your Lordship kindly come to 3, your Lordship, serial number 3, your Lordship. For EWS candidates, your Lordship, the cut-off mark is 133.5, your Lordship. Now, if your Lordship kindly assume, your Lordship, the person who the highest mark holder got the whole mark, 5 of your Lordship, 102.5 plus 24 for 5 of your Lordship. That person will reach, your Lordship, get 126 marks. The RTI itself reflects, your Lordship, the person, the highest mark holder is not even the person who reached the cut-off mark, your Lordship. How the selection process can be fair, your Lordship.
Where is that person appointed on the EWS?
That 6 and 7, your Lordship. Because there are 3 reserved category, your Lordship, for male person, your Lordship. One female category is also there and not, your Lordship, implemented by your Lordship. Only the male category, your Lordship, male person, your Lordship, under EWS category, your Lordship.
Why is it for orders?
Is it because of this address, your wrong address in the 6 and 7?
Because of the IA, Lordship, that the petitioner have filed 3130, my lord. 3130/2024. That IA, I have filed my reply, my lord. That reply, my lord, may kindly have a look.
Your Lordship, because
I is disposed of.
no, that was not your Lordship. Because
Another IA, my lord. 3130.
130 is disposed of.
disposed of, your Lordship.
That is-
Here, your Lordship, 6 and 7 subsequently implemented, your Lordship. 6 and 7 address is little bit incorrect, your Lordship. That is, instead of Kamrup,
Tripura, Commissioner MSW for the Transport Department, and Mr. T.P. Dotto for APLP. The petitioner submit that in terms of the laws in my court order dated 2005/2025. Address of the duty address of the 6 and 7. Required some- So, counsel for the petitioner therefore submits that she be permitted to correct the addresses of respondent 6 and 7 and thereafter file admitted both side. Prayer made is not objected to by the respondent. Accordingly, let the correction be carried out within 1 week. Therefore, placed accordingly after 1 term.
Oblige, Lordship.
Oblige, Lordship.
Yes, Malad, I pray for some time, Malad, to find my amended cost title, Malad. The order was passed on 17th of February, Malad.
Regarding and counsel to the petitioner for another 2 weeks time to file an amended court title. Mr. G. Bora for the
All right.
after 2 weeks.
Here we have received the PROS comments, we'll be filing the affidavit here. IPF for respondent was 1 to 5.
As per Office Note 14/5/2025, steps on respondent 6 has been shown to be completed as the consignment tracking report available in the record indicates that notices were successfully delivered on 13/2025. So that view of the matter. Steps on respondent number 6 stands. Meanwhile, the government counsel submits that instructions have been received and you'd like to file an affidavit. Praise for
2 weeks time, Milord.
2 weeks time. Please for admission.
A date may be given, Milord.
2 weeks, some date will be given. Let him file.
Service upon respondent number complete, Malad. Net pen appear for others while PGSC. Also will file our affidavit in this case.
Your file
Will file the affidavit.
as per Office Note dated 14/5/2025. Stands completed. Other respondent, however, none appears for the years. Then the respondents complete their pleading, complete their instructions and file necessary affidavit to advise in the meantime. At least after 3 weeks. For me, it was the
May I pay for date may fix, Malad? Person is out of service, Malad, after completion of 20 years service.
list on 20. 0. June.
Much obliged.
None appears for the parties, the matter being called. Petitioner on call, MSM Bhattacharjee appearing to the case for the respondent authority. Any instructions here?
Lordship, instruction not yet received, Lordship.
Matter be listed after 1 week.
Item 50. Give office note lordship 22/5/2025 lordship. Service report is awaited, but the track consignment report shows that on 7/5/25 item has been delivered.
Pursuant to issue of notice, steps were taken as per Office Note 22/05/2025. Although AD card is not yet received, tracking report, consignment tracking report shows that the item was delivered on 7/5/2025. Two. Which respondent?
Respondent of 5 lordship.
Respondent 5.
In item 56 lordship, he is the petitioner.
Who's for the other respondent?
The lordship, railway lordship and petitioner SBI lordship.
However, none appears for.
Madam, Mr. Gupta appears in this matter, madam. He is on legs in court number 1.
So, what instructions do you have?
Madam, brief is with him only, madam. Brief is along with sir only, madam. And pass on.
Which Gupta? You say H. Gupta
H. Gupta, my lord.
represents the respondents 1, 2, and 3. 1, 2, 3, and 4. However, none appears for respondent 5. Let the respondents complete their pleadings. Matter be listed after 3 weeks. T6.
I put the petition 66.
56, yes.
Because
Why are they connected?
the interrelated.
Yes.
Response number 4 is the petition in item 55.
Huh?
Response number 4, my petition is the petition in item 55.
Okay. Somebody was filed, rejoined the petition.
They had filed the affidavit, but your lordship will not be filing the reply, your lord, because it is admitted that she is married, your lord.
What is the claim here?
Lordship, my claim is, once I've given compulsion appointment, your lord, if your lordship has page 15, your lord, of my petition.
15.
Yes, your lord. This is an order, your lordship, effective paragraph 11 in page 17, your lord. One-third of my salary was supposed to be given to the respondent number 4, your lord, until she gets married. And the respondent number 4 in an affidavit has admitted that she has got married in year 2022.
After that, what happened?
Lordship, the respondent 4 has filed the affidavit, your lordship.
No, after this order, page number.
Lordship, there is an interim order, your lordship, passed on 5th of August 2022 in this petition, your lordship. And the petitioner was given the compulsion appointment.
So what is your prayer now?
Your lordship, the one-third of the salary and 50% pension has to be stopped because he has got married and is admitted by the respondent number 4 in her affidavit. As per the, in terms of the division bench order, your lord.
Lordship, the item 55 and 56 why connected lordship. Lordship may kindly see the page 15 lordship, paragraph 8 lordship.
Oh.
Of this lordship item 56 lordship.
Yes.
Page 16 lordship, paragraph 8 lordship. Here is lordship.
Great.
So far as DCRG amount is concerned, which is the sum of rupees 5,79,360, it is pleased case of the Northeast Frontier Railway that the said amount is required to be disbursed 1/3 each. However, the same could not be disbursed because the government accommodation is still being occupied by the occupied by Srimati Sayadas petitioner Lord. As assurance has been given to this court that if Srimati Sayadas vacated the accommodation, the DCRG amount would also be disbursed in ratio of 1/3 each in favor of the petitioner Piarani Das, daughter from the first wife, Srimati Sayadas, the second wife, and Miss Riya Das, daughter of the second wife, Lord. Lordship, thereafter, Lordship, this petition was filed by me, Lordship. Thereafter, Lordship, this case was disposed by the order, Lordship, 39/2020.
So you're referring to?
He's referring to page number 15 of my petition, Your Lord.
Yes, 16, Lordship. Yes, 16, paragraph
But
8.
this is a division bench order.
Yes, Your
Division
Lordship.
bench order.
This is of 31st of August 2020. And I vacated the accommodation on 23rd of November 2020.
Is it on record?
No, I have been provided the document, Your Lord. By my client, Your Lord.
It should have brought.
Subsequently, it was provided, Your Lordship.
Now you're entitled to 1/3.
One third has been stopped as per the interim order of this court, Your Lordship, and 50% pension has to be stopped, Your Lordship.
Where is their interim order?
5th of August 2022 in my petition, Your Lord. 1/3 of the salary has been stopped.
Fifth of August.
2022.
In this writ petition.
Yes, Your Lordship. 3095/2020.
Yes, then
Now, as she has married, it's admitted in the affidavit, it has to stop the
It has
pension
been-
also, Your Lordship.
This has already
there is already an order.
Yes, sir. 1/3 has been stopped. The pension has to be stopped, Your Lord.
Pension is not I am getting, Lordship. Only 1/3 of the salary was
5463 says once he gets married, he or she. The CCS rules, Your Lord.
after this order of this honorable
By
court,
which order you're referring to? 31/8.
31(8),
Paragraph.
page 11, paragraph 11 of 17, Your Lord, page 17. Pension issue will be at paragraph 5, Your Lord. Sorry, Your Lord.
So where is that direction? Where is the direction that it has to be stopped?
The 5463 says once
Lordship,
he or she gets married,
item
the
55
pension
I
will
have
be stopped, Your Lord. But it has been directed to pay half to the respondent number 4.
in item 55 I have annexed that order, Lordship, whereby this honorable court has directed to stop the payment, Lord.
Stop the.
Payment of that 1/3 of salary, Lord.
So we are only 1/3 of pension.
Yes,
Half-
1/3
half of
of
pension.
the salary has been stopped as per the interim order passed by the honorable court. Your Lordship, now as the respondent was admitted in an affidavit that she has got married, 5463 says that.
No, you were referring to para 5,
Yes, Your Lordship.
where it is pointed out that superannuation is paid half.
Yes, Your Lordship.
Is there anything in the order which says that it will be stopped once she gets married?
That not at to that point, Your Lord.
Lordship, that case was disposed of by the order, Lordship, 39/2020, Lordship. Lordship will find that page 18 starts from page
Only it
18.
has been mentioned in the order paragraph 5 in accordance with rule. last line, the paragraph 5.
According to the division bench order, lordship, I am entitled for 1/3 of the DCRG loss, and that amount has not been yet paid, lordship. And the respondent number, the present petitioner lordship has been directed to vacate the government.
First, tell me that salary 50% is stopped.
One third.
One third.
One third.
Stop.
That is stopped,
Stop.
lord.
As per this direction of the Honorable
Direction of
Judge,
the
Lord.
Then comes
No.
pension.
Pension, Lord.
Pension I am not getting, lord. I am
You are
not
not
getting.
getting or you're not entitled to get.
Lordship, because since I have married, I am also not entitled, lordship. I am also not entitled because since I am married, lordship. I am only entitled only 1/3 of DCRG amount, lord. That has not been paid, lordship. Since lordship,
So, but you are getting the pension.
pension I am not getting, lordship. Only
Who's
1/3 of salary.
the railways?
Age group.
Railway can confirm, lord. I have annexed that.
Yes.
Item 55, my lord, the direction which has just now been read, para 8 of the division bench order. The grant of DCRG was not subject to vacation of the government accommodation. It was done subsequently.
2020. 23rd of November.
After the division bench order, it was vacated, my lord.
Vacated, lordship. I am entitled, lordship. Since 2020, lordship, I am not getting that. That's why, lordship, item 55 is connected, lord. The authorities can clarify whether they have vacated, lordship, because the authorities are not paying me since 2022, lordship.
Yes.
That decision I will take, my lord. If they have vacated, they are entitled, my lord, 1/3 amount. That we have also admitted, my lord, the division bench in the
Any affidavit filed here?
In my petition, Railway has filed the affidavit.
What would they say?
It was filed on 20, must be on 25th of October 2022. And paragraph 6, they have stated that they are not been informed regarding stopping of 50% of pension along with 1/3 salary. And in paragraph 7, they have stated they will stop if they are given the information.
Has already been stopped.
If the respondent who admits her marriage, then will be able to stop her allowance, as stated in paragraph 7 of the affidavit filed by the Railway Authority.
What have they stated in their affidavit? You say that you have vacated it.
I have vacated it.
When?
On 23rd of November 2020. This is an order here. If I am allowed to produce it, the order.
2020.
2020 year out. 23rd
After
of November.
the
Immediately after the division bench order year out.
So that affidavit is filed in 22.
Yes, year out.
Is there any indication that you have vacated?
There is no indication, Lord.
Then
Lordship, in item 55, if authorities file affidavit, lordship, and clarify this to lordship, then everything will be clear, lord. But as per lordship, page 21, lordship,
Paragraph 8 in page number 16.
Lordship.
Some assurance is given. Who
Yes,
gave
sir.
that assurance?
Thereafter,
Pardon me,
Lordship,
Who gave the assurance to the court?
the petitioner, Lord.
I have taken it, your lordship.
Read para 8, page number 16.
By the petition item 56. Assurance is given by the petitioner. Name and also mention, your lordship. Either. This is the petition item 56.
Who is the petitioner here?
Chayadas, your lordship.
You have given the assurance.
Yes, your lordship.
How can you give the assurance? The CRG amount is to be released by whom?
It has to be
By
authority.
the authorities, your lordship.
Then?
It just stopped only because I was holding the accommodation, lordship, of my late husband, your lordship.
And this is paragraph, page 21, paragraph 4, Lordship. I think it was clear, Lord. Page 21, paragraph 4, Lord.
Okay, heard. Department. Mr. Your name?
I am J. Abbas, Lord.
A. Abbas appearing in item number 55
PPF for petitioner, Lord.
for the writ. And Mr. A. Das appears for the writ petitioner in item number 56.
56, your lordship.
Mr. A. Gupta appears for the writ. For the matter. The petitioner in 55 is the daughter of the first wife
Lordship.
Yes, your lordship.
of late Rana Chandra Das, who was an employee of the Indian Railway, NF Railway. So the petitioner in item 55, petition number 20, was born out of the marriage of late Rana Chandra Das, his first wife named Vidya Das. Pursuant to the demise of the mother of the writ petitioner in item 55, late Vidya Das, the employee, namely late Rana Chandra Das, subsequently married the writ petitioner in item 56. So, pursuant to the demise of late Rana Chandra Das, claims have been raised before the railway by the daughter of the first wife, namely petitioner in item 55, as well as by the second wife, that is petitioner in item 56, as well as the daughter of the second wife.
Yes, your lordship.
So, this issue came up before a division bench of this court in WPC 3006 of 2009, which was filed by the petitioner in WPC, petitioner in item 56,
55, Lordship.
55. So, in the order passed on 31/08/2020, directions were issued that in the order they passed on 31/08/2020, the division bench recorded on the basis of submissions made before the court that the DCRD amount which is a sum of rupees 5,79,360 is required to be dispersed at the rate of 1/3 each between petitioner in item 56, 55, the petitioner in item 56, as well as the daughter of the petitioner in item 56. However, the same was not dispersed as the petitioner in item 56 was occupying an accommodation, railway accommodation, and the same would be dispersed immediately upon vacation of the said accommodation by the petitioner in item 56. It was also recorded that since the second wife, namely petitioner in 56, was given compassionate appointment, she will continue to give 1/3 salary to the writ petitioner, namely the petitioner in item 6, till she gets married.
Petitioner in item 55, Lord.
She will give 1/3 of salary to the writ petitioner in item 55 till she gets married. Fair. Subsequently, the petitioner in item 55 got married on
17th of February 2022.
where is it reflected?
In the affidavit filed by the respondent for even in my reputation log at page 27. There is a marriage certificate.
In my affidavit, Lord, page 40, Lord.
Annex 6, page 26, the type copy.
Where is your affidavit?
Lordship, page 40, Lordship, paragraph 12.
Of
Of Lordship,
In item 56.
56.
Yes, your lordship. Page 40, paragraph 12.
The petitioner in item 55 was married off on
27/2/2022, Lord.
page number.
Page number 40, Lordship, paragraph 12, Lord.
Got married on 17/2/2022. This fact is also admitted by the petitioner in item 55, who is also respondent number 4
Yes, your lordship.
in item 56, by writing an affidavit and an averment that effect is made in para 12 of the statement. So, under such circumstances, in terms of the orders dated 31/8, 2020, the railways are now required to release the DCRG amount at the rate of 1/3 each in favor of the petitioner in WPC, the petitioner in item 55, Srimati Priyarani Das, petitioner in the item 56, Srimati Chaya Das, and Srimati Priya Das, daughter of Chaya Das, as the petitioner in item 56 has already negated the railway accommodation, and there is no dispute to that effect. So, a in that view of the matter, view of the order dated 31/8/2020 passed in WPC as reported in the said order, the direction to pay 1/3 salary to the petitioner in item 55, namely Priyarani Das, will cease to continue with effect from the date she stood married, namely 17/2/2022.
Yes, your lordship.
So you have continued to pay till today.
No loss.
The interim order was passed on 5th of August 2022. After that, it has been stopped. 1/3 of the salary of my salary.
In terms of the order passed by this court on 5th of August
Yes, my lord.
2022, the said salary had already been stopped. As of now, the only question left to be decided in the writ petition is the release of the CRT amount amongst the claimants. So, Mr. Das has placed before a court uh, a certificate issued by the area manager and a Braidway Potterpur to the effect that quarter number capital T/50 within bracket capital A, type Roman 1 at traffic colony PPP was vacated by Srimati Chaya Das, wife of late Rana Chandra Das, on 11/11/2020. So, it's submitted by the petitioner in it's submitted by Mr. Das, counsel for the petitioner in item 56, that in terms of the order dated 31/08/2020, in the CRT amount is to be released by the railway at the rate of each. Once the railway quarter to be vacated by the petitioner in item 56. So, in view of the certificate issued by the NF Railway area manager NF Railway Potterpur dated 23/11/2020, it is evident that the railway quarter has been vacated by petitioner in 56 on 11/11/2020. Therefore, in terms of the order dated 31/8/2020, passed in the 56, the railway authority is now required to disburse the ratio of 1/3 each, the DCRT amount in favor of Srimati Priyarani Das, petitioner in item 55, Srimati Chaya Das, petitioner in item 56, and Srimati Riya Das, daughter of Srimati Chaya Das. So, the railway authorities will do the needful as expeditiously as possible within the outer limit of 30 days from the date of receipt of a certified copy of the law.
You mean that?
56. Since this was the only issue left to be decided by the court in view of the directive, the writ petition stands closed in terms of the direction above. Copy of the certificate issued by the area manager and Braidway dated 23/11/2020 is retained the case.
Pushpendra is also not entitled to pension, you know.
Huh?
He's also entitled to pension, you know.
Are you claiming that?
No loss, I am not paying.
But it is mentioned in paragraph 5, your lord. Superannuation pension is being paid after the petitioner.
Not monthly pension, I will not be paid. I will not entitle because of it.
But that is already stopped.
Yes, sir. In absence of lordship, monthly salary lordship.
It's only stop, but there may be direction, your lord.
Huh?
Otherwise,
Huh?
there has to be direction of stopping the monthly pension, your lord.
That's already stopped by an order.
Yes. 1/3 has been stopped, your lord, not the pension, your lord. 1/3 of the salary from my monthly salary, your lord. That has been stopped.
Pension under
5463 of the rules, your lord. It is-
All other entitled has been paid lordship except DCRG lordship. And only lordship 1/3 of the salary was paid in exchange of lordship that family pension, monthly pension law. And that has been stopped lordship by this. So lordship,
Paragraph 5 of page 15 of my petition.
there are the rules.
Yeah, that's allowed. 5463, your lordship. Down below the.
It is also made clear that after the rule 54, the railway follow the CCS pension or you have your own pension rules? Are you sure? See, railways have their own pension rule.
Keeping your lordship, the PT responsible for in her affidavit stated that she has received family pension amounting to rupees 9,301.
That was earlier, Lord.
She had received, but now it will stop because he had got married.
You have your own pension rule. Then CCS will not apply.
And that pension was paid, Lordship, earlier to the payment of 1/3 of salary, Lord.
These are two different things, your lordship, pension and 1/3 salary.
No pension. No pension. Before that.
Where are your rules? Pension rules.
Almost today we are not taking otherwise lordship, he is not getting the only 1/3 salary. So let's put it was already issued.
Then why unnecessarily write?
Yes, your lordship. Your lordship,
Huh? Wait between then both the written.
He reflected that.
Mr. For item 55, starting counsel, page CGC, and Mr. K. Gogoi in item 56. Standing on.
Deeply obliged.
I may take back the document, your lord.
No, we are retaining that certificate.
I'll
Certificate.
provide the Xerox copy of the same, your lordship, if your lordship allows.
We'll help ourselves to a Xerox
Much obliged.
copyright.
Oblige, your lordship. Well, all these cases are covered by the judgment of the division bank, you know. I am placing the judgment and order.
What is the matter?
My matter, subject matter is that there was a demand notice issued by the Mental Health Institute of Peshpur. That was on the claim that it is an excess payment. So learned single judge has rejected the prayer and said that there is no scope to recovery. Then they have challenged it in appeal. In appeal also same order was. It was upheld by the single judge.
Yes.
We don't have any of.
Hmm?
We don't have any of. It is a covered matter.
No, your objection or not, are they covered by this?
Yes.
Yes, Mr. No,
It's covered, matter.
covered by writ appeal.
Very good.
Council of the bar submit
And-
that the issues raised here stand squarely covered by the judgment and order dated 13/5/2025, passed with WP 506 of 2021.
Covered.
So it's covered by judgment of 13/9/2022. Passed
Yes,
with WPC 258 of 2022, and which judgment stood upheld by the division bench of this court in writ appeal 132 of 2025, along with other connected petitions, therefore that's allowed. The recovery sought to be made from the petitioners, therefore there's some order passed for recovery.
Yes.
Impugn orders dated so and so, therefore stands prepared to then set aside.
No. 13 also same,
1 minute.
and thereafter 37 to 42.
Retake
37 to 40.
42.
Have you checked up all these matters?
Yes, my lord. But in writ appeal, my lord, in earlier writ petition, my lord, that was considered in the light of the Rafiq Masih case, my lord, treating the post of the petitioner as Group C post. But in writ appeal, my lord, it is in they are holding the post of category B, my lord. This is the same, my lord. But
But that will
because
not
of
come
delay,
because the appellate court has
Ultimately, the recovery has been
recovery, my lord,
been
because of
stopped,
delay.
has been rejected. Prayer for recovery rejected.
Rejected.
Let us say,
Yes. Obliged.
well, with the-
This is for the against the recovery. Okay. After retirement, my lord. Recovery, taxes amount, recovery after retirement, my lord. There, nobody has filed the affidavit, my lord, till date, my lord. And the finance has been newly imputed as a party responsible.
I have received the instruction, and this is pertaining to recovery due to overstay. Now, administrative department here being, my lord, the PNRD department, Panchayat. We have written a letter, my lord, to the Panchayat department, but no instructions are forthcoming from them. So unless we have the data, my lord, being the nodal department, we are
Yes.
not in a position, my lord. I have the instructions, my lord.
Panchayat, you request him, take it up. Mr. D. Borua for the petitioner, Mr. Bordaloy.
I'm the Guru.
D. Borua, yeah, for the petitioner, and Mr. R. Porpudari and A.K. Ghosh on behalf of Finance and PNRD, respectively. Counsel for the respondents are permitted to complete their instructions and file affidavits if they are so advised.
Kindly observe, my lord, we have sent a inter-office communication.
You procure instructions between you. Why should we record it? What is the use of sending a letter?
If lordship makes an observation, my lord, that we have taken up the matter with the PNRD department, but nothing is forthcoming from their side. Okay.
There is an interim order, maybe.
Interim order passed earlier, if any, will continue.
Obliged.
Taken on 20 June.
20.
Obliged.
Lordship, can this matter be taken up on Friday, Lordship? I'm accepting some
Right.
instruction, Lordship. Some instruction to be provided by the government, Lordship. So, Lordship, I'll receive it by today, Lordship. So, can this matter be taken up by Friday, Lordship, 30th?
On the last 9 occasions, they have not produced any instance. Later, they have filed the affidavit. The petitioner later in the year of 2018. And since then, now the petitioner is 66 years old.
Friday.
Expecting, my lord.
It's on Friday, as paid for by Mr. D. Upamanu, counsel for the Health Department. Mr. A. Boro.
A. Boro, yes.
Appears for the writ petition.
Highly obliged.
This is last question directly given to a parent.
Lordship, I am told by my client, Lordship, that they are doing the needful to pay the pension. Lordship, that it takes for some time, Lordship, to do the formalities. Lordship, in fact, Lordship, the petitioner's date of birth has some discrepancies in the date of birth of the petitioner, Lordship. So that has to be looked into. Lordship, fix the matter after 3 weeks, Lordship. In the meantime, the authorities will do the needful.
23 matter.
Lordship, I understand, Lord. In fact, it is returned from the AG, Lordship, with certain queries, Lordship.
Mr. N. Upadhyay, Standing Council, Irrigation Department, is not further time. Mr. APT Hawk. It's taken after 3 weeks.
Lordship, Lordship. Lord.
Get your instruction.
Lordship, Lord.
Lordship, here I am appearing on behalf of MSP Bora, Lordship. Due to some medical emergency, Lordship, she is not available today, Lordship. Can this matter be taken up after 2 weeks, Lordship? Her husband has been hospitalized, Lordship.
What is the matter?
Matter remains is that, brother, the petitioner, brother, they appear for a selection of driver, brother, the Tezpur Medical College. That advertisement was issued in 2011. Then due to some reasons, brother, they did not announce the result. We filed an application petition before the Honorable Court, and Honorable Court in 2018 directed them to furnish the results within 2 weeks. Now, what happened, my lord? They did not inform the Honorable Court even during that time that by an subsequent notification dated of 2018 itself, the entire selection process got cancelled. They kept mum, my lord, and because prior to the issuance of the order, that notification has already come out. Now, my lord, when we filed an RT application subsequently, we came to know that many grade 3 posts were already been filled up. Though they say that the entire selection process was cancelled.
We'll have it on Monday.
Monday.
Lordship, can it be on Wednesday, Lord?
Wednesday.
Yes,
Right, 4th.
20?
It's on 4th June.
4th June.
Obliged.
As it is submitted on behalf of the respondent that the standing counsel is
MSP
not
Bora.
available in court. Standing counsel MSD Bora
Yes,
is not available in court because of
medical.
medical emergencies arising in the family.
Highly obliged.
Hold on.
Your Lordship. Lordship, my senior Mr. Edgebrugger is on legs. May this matter be taken up after some time.
Hmm?
My senior Mr. Edgebrugger is on legs. May this matter be taken up after some time, Your Lordship.
Anyone for the respondents here? Who's for the respondents here? Let it come next week. Please, next week.
Much obliged.
The request made on council.
Please, Lordship. Lordship, your matter relates to selection and appointment of Gauhura. Lordship, in the meantime, an appeal was filed, Lordship, and hearing has already been completed as per my instruction, Lordship, but no order has been passed. So it may be taken up after 4 weeks, Lordship.
Who filed the appeal?
Lordship, the present petitioner.
You filed the appeal.
Okay, appeal filed, Lordship. On the last occasion, Honorable Court has granted liberty to file appeal and consider it.
Let the if you're aggrieved, then that appellate order, you'll have to challenge it.
Order has not been passed in the appeal, Lordship.
We'll direct them to pass an order and close it. Yes,
As per my telephonic instruction, Lordship, if the hearing is concluded, of the appeal, they will file, they will pass the order within.
when was the hearing concluded?
Last day, last day. That information I don't know. Just now they said that the appeal is, the hearing is concluded, Lordship.
Heard and counted to the parties. This written is filed with the consider challenging the challenging the selection of respondent number 5, the post of Gamura. So which village is it?
It is, Gaopara,
Dwarpara.
Duarpara,
Dong-
Dongpara,
Dwarpara
under
slash
Dolgaon
Dongpara Revenue Village. Being agreed, the petitioner filed an appeal. Stop. The appeal filed an appeal on 2005-2023. Stop. However, the appeal not being disposed of, the present petitioner is filed. Stop. Today, when the matter is called up, counsel at the bar submits that during the pendency of the writ petition, the appeal, the hearing in the appeal has been concluded. However, the order has not yet been passed. So, who is the appellate authority?
Appellate authority, the principal secretary, Lordship.
Now Director of Land Record and Service, Lordship. DLR.
Are there respondents here?
No, he is not there.
If that be so, then the appellate authority may pass an order as expeditiously as possible within a period of 60 days
Lordship.
from the date of receipt of a certified copy of this order. Let this order be communicated to the appellate authority, to the office of the Commissioner and Secretary, Government of Assam, Revenue and Disaster Management, LR Department, District 106. Writ petition accordingly stands disposed of. Needless to say that any order that is passed, a copy of the same shall be served on the writ petition. Needless to say that the petitioner may approach this court again if the grievance of the writ petitioner still subsists. Therefore, Mr. D. Bora for
3 and 4.
3 and 4, Mr. A. Pugan for
Number 2.
respondent.
I'm first
Yes,
number 1.
also for respondent 1.
Public.
May please, your lordship. Lordship, the matter basically relates to correction of date of birth. The issue involved in this case has already been decided by this court, lordship, and complying the orders, court's order, lordship, and followed by report, speaking order has been passed, lordship. In the speaking order, one aspect is only required to be examined, lordship. First of all, your lordship may kindly come to the page number 42, Annexure M. This is the court's order, lordship. Direction was at page 44. After the court order, Lordship, I submitted representation, Lord. Enclosing all the relevant documents, Lordship. Which is at page 46.
Then
Then Lordship may kindly come to the page number 49. A report was issued by the concerned authority, Lordship. Page 49, type copy, Lordship. On receiving your order, I have inquired upon the authenticity of the school transfer certificate submitted by Sri Devanand Pongla, Handyman, Office of the Executive Engineer, PW Maibong Division, and have derived the following conclusion. Number one, the name mentioned in the transfer certificate was seen to be Sri Devanand Pongla, sir, does not match with the above mentioned name. The date of birth mentioned in the transfer certificate was seen to be 28/1/1971, same Lordship. On validating the transfer certificate with the principal, Maibong Higher Secondary, Maibong, Dimahasar, the transfer certificate was found to be authenticate as per school records. As per the verification report of the principal IC Maibong, it says Maibong, Dimahasar, the date of birth mentioned in the transfer certificate was found to be correct. But if that certificate was found correct, thereafter, Lordship, speaking order was passed. During the pendency of contempt proceeding, Lordship, speaking order is at page 54. Page 54.
Yes.
So I have SL there. The petitioner's date of birth was recorded on 10/2/1963 in his service book, which the petitioner disagreed and claimed to be correct. As per petitioner, his actual date of birth is 28 January 1971. According to the Finance Department's the undersigned requested the Deputy Commissioner, Dimahasa, for verification of concern, verification of correctness of case in the matter of Sri Devanand Congress of height is letter number so and so, dated so and so. Verifying the correctness of age of Sri Devanand Panglo, the Assistant Commissioner Maibong Dimahasa District submitted its report where the name of the petitioner, Sri Devanand Panglo, was recorded in the school transfer certificate as Devanand Panglo, sir, which does not match with the name of the petitioner, Lordship. On that count, Lordship, claim was rejected, Lordship. And regarding this discrepancy, Lordship, Honorable Supreme Court, Lordship, very recently passed a view, Lordship, in one foreigners tribunal matter, Lordship.
what is that?
Lordship, 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 page number 59, Lordship, paragraph number 54, Lordship.
Fifty-four.
54, paragraph number 54, Lordship.
Huh.
For and on the strength of the totality of reasons before indicated, this court finds that the report, opinion of the tribunal dated so and so as sought by this court, so order dated so and so is wholly unsustainable. Accordingly, the report, opinion dated so and so is quashed. As a report, opinion dated so and so has been examined, Lordship, Lordship, page number 60, Lordship, paragraph number 55, Lordship. Lordship, 55. This court has found that the inference drawn by the tribunal do not falsify the appellant's claim. In view of the details analysis, the discrepancies in the materials produced by the appellant can be termed minor. The same will not sufficient to lead the tribunal to doubt and disbelieve the appellant and the person put forth by him. Lordship, same Lordship. Here, Lordship, my name was recorded as Devanand Panglosa. Normally, in case of tribal, Dimasa tribes lordship, that size added lordship.
On what basis are you making that?
Lordship.
This submission that you're making that Ponglo and Ponglosa are one and the same person.
That's the same person, lordship.
No, mere submission will not do. You have to lead evidence to that.
Lordship,
effect.
lordship,
Where is
during
that
the
evidence?
during the time of lordship joining, I submitted that certificate itself. That was only at a school certificate, lordship.
That is all right, but the report is very clear that it is in the name of Ponglosa.
Ponglosa, your father's name is also same, lordship. Everything is same.
Yes.
Yes, Lordship, I'm on behalf of the respondent number 4 and 5. Lordship,
Who is 4 and 5?
Lordship, NCL's Autonomous Council Principal Secretary.
Yes.
Lordship, I pray for another 2 weeks' time to file our affidavit.
You come to page number 49.
Yes, sir.
So this is a report by the Assistant Commissioner.
Yes, sir.
In para number 3, it says on validating the transfer certificate. It has been found to be authentic. What does one make out of this? Authentic in what sense? Three and four.
Lordship, this is not our instruction. This one is.
Where is
this
the
one- respondent number
verification?
6,
Where is
Lordship.
the verification report of the principal? Mr. Doctor,
Lordship,
where is the verification report of the principal?
that I have not annexed, lordship.
Please hand it over if you have. Do you have a copy?
No, lordship. No.
Okay.
This was written report.
Mr. Ayok, you are appearing.
Yes. Kindly see page 44.
44.
The operational portion, lordship, kindly.
Yes.
Lordship, at bottom paragraph, from third line down. Page 44. The writ petition is therefore disposed of by directing the petitioner to submit his full certificate, matriculation certificate before the authority within 7 days. So it was for him to submit the certificate. Now, once the certificate has been submitted, lordship, it was forwarded to the commissioner for verification. That is page 49. Page 49, lordship, may kindly see, here we are concerned with a person, Devanand Ponglo. Certificate, it is written as Devanand Ponglo. In serial number 1, it has been clearly mentioned, the name mentioned in the transfer certificate was seen to be Sri Devanand Ponglo, which does not match with the above mentioned name. That is 1. And 3, lordship. On validating the transfer certificate with the principal in charge Maibong HS School, Maibong, Dimahasao, the transfer certificate was found to be authentic as per their school record. So school issued the certificate to a person, Devanand Ponglo. It may be different, lord. So two aspects are there. One is the name of the petitioner, and second one is exact date of birth. Lordship, on the basis of this, lordship, authority took the decision at page 54. Paragraph, lordship, verifying the correctness of age of Sri Devanand Ponglo, the Assistant Commissioner Maibong Dimahasao District submitted its report, where the name of the petitioner was Devanand Ponglo was recorded in the school transfer certificate as Devanand Ponglo, which does not match with the name of the petitioner. On considering the report of the Assistant Commissioner Maibong Dimahasao District, the NCHAC authority is not in a position to rectify correction of the age requested by the petitioner Sri Devanand Ponglo. Now, it is for the petitioner now, lordship, to show
That Devanand Ponglo and Devanand Ponglo sir, the same person, one and same person. Only thereafter, Lordship, it will be expedient for the authority to take a decision in this regard. That is my only.
Yes.
Lordship, in my other documents, my name was on as Devanand Ponglo.
No, no, see, first thing you are asked to submit a school certificate
Lordship,
or a matriculation
Lordship,
certificate. What is seen to be considered is a transfer certificate.
Lordship,
Direction of the court is matriculation or
school certificate.
school certificate. So this will be in your possession.
Sure.
You are required to submit it.
Lordship, I have submitted, Lordship.
So you have submitted whatever you have submitted, but the report says it is a transfer certificate.
Transfer,
It is not a matriculation certificate.
not matriculation certificate.
And the report does not say that the certificate belongs to you or does not belong to you. It says it belongs to Debanon Ponglosa. Now, whether you and that person are one and the same, that report is not clear. This report is given again on the verification report of the principal. So all these materials you will have to procure to say that the direction of the court has not been complied with. Direction of the court is clear, matriculation or school certificate. What is seen to be examined by the report is transfer certificate.
Transfer certificate. Full transfer certificate.
Do you have a matriculation
No,
certificate?
Lordship. No. Certificate is at page 24, Lordship. Page 24.
You will have to examine the school records.
Lordship.
You will have to get the school records.
So, Lordship, remand
See,
the matter.
if you see page number 24,
24.
read the name of your father.
Naisaran Ponglo. Ponglo, sir.
Ponglo,
Naisaran Ponglo, sir.
And read the name of your father at page number 3.
Naisaran Ponglo.
No, this is not nice or on. This is Nike prawn or nice prawn.
Strong. Lordship, may kindly come to the page number 22. 22. 22. Page number 22. In my appointment letter, Lordship. Naicharan.
That is right, nice or on.
Naisaran.
But the name is, the course title is
Lordship.
slightly different.
Lordship.
And again, here you have written Ponglo.
Ponglo.
Who is the authority to give a certificate as to whether these two persons are one and the same?
No, Lordship, court said school certificate plus matriculation certificate.
He is not a matriculate.
He has not submitted his matriculation certificate.
He is not a
I
matriculate.
am not
Yes,
matriculated.
sir. So school certificate was submitted, it was a transfer certificate. Lordship, even that would have been, that would have covered his case, sir, if that would have reflect his name correctly. Now, very small issue, Lordship. Let him show that he and the person mentioned in the certificate. Same person.
That can be done only by the principal, Lordship. School principal, Lordship.
Can get it done by the school principal.
So, Lordship, remand back the matter to the principal, Lordship.
Principal, not a party here. Principal is not a party here.
May I leave process in another, one of my country.
You have to bring some material on record.
Lordship, I have annexed, Lordship, my PAN card, Aadhaar card,
Showing what?
page 34. Is the Aadhaar card, Lordship.
It's all Ponglo,
Ponglo.
Uh.
I am originally Ponglo, Lordship. I am not Ponglo, sir, Lordship.
but the certificate you have presented is Ponglo, sir.
Lordship, that was issued by the school authority as Ponglo, sir. In my PAN also,
Your
it is,
mere statement will not help. If you want some time, we'll give you some time to get something on record.
Lordship.
Otherwise, we are not embarking on a inquiry to find out whether both the persons are one and the same. List again after 3 weeks, enabling the council
Obliged, Lordship.
to bring on record additional affidavit, additional documents if so required in support of his case that Lebanon Ponglo and Lebanon Ponglo Sak are one and the same person.
Obliged.
Respondents are also at liberty to file their counter affidavit if so advised in the meantime. Please record it. That's it. Yes,
You will receive affidavit opposition filed by the respondent number for lordship. So we want 10 days time to file a reply.
counsel for the petitioner submits that time, prays for 2 weeks' time to file their rejoinder affidavit. The affidavit
And
filed
that
by
may
the
be
respondent
lordship.
number 4. Respondent number 4,
Yes, Lordship.
MSM Bhattacharya appears for the list after 2 weeks,
That may be fixed lordship.
20 January, sorry, June.
May I please, Lordship? Lordship, the prayer for the regulation of service of the petitioner. She is working since 1989 under Golaghat Jilla Parishad as a Safai Karmi on contextual basis. Because of contextual basis, she could not get all the benefits. So my prayer for before the Honorable Court to regularize the service.
Your prayer may be there, but you have to support it with the law that you are entitled to regularization. What is
I'm
your
working,
entitlement?
I'm working since 1989.
No, what is your claim for regularization?
And my colleague also, my colleague also, they are
Regularized.
regularized.
Yes,
The colleague part she is talking about, we don't know, there is nothing on record. So which colleague or what?
I
you
would,
filed your counter.
No, we haven't filed any counter.
You file your counter.
representation,
Hmm.
representation filed also to the respondent, but they could not consider. So my humble prayer for to the Honorable Court, kindly to direction.
Not like that. We can't direct them to regularize because you want it. You have to show on what basis, what is your belief? What is the law for regularization? Orders of the court are not for the asking, you have to support it. You are working, was there by way of a regular selection? No, you are on contract. Now, when your entry into the service is not through the regular process, you can't, your appointment cannot be said to be regular as per the route. So where is your claim for regularization? Then you are saying that similar persons have been regularized. Where are the particulars? Who has been regularized? Yes. You are an employee of Mahkuma Parishad. Mahkuma.
Right now, I'm Golaghat Jilla Parishad.
Golaghat Jilla Parishad. Let's you show us what is the basis for your claim. You file your affidavit. Tell us why you are appointing people on contract basis. Why not on regular terms?
We also, we don't have instructions, but Safai Karmachari, I don't know whether there is sanction post.
Get instructions. Heard conflict for petitioner and go to the council if there is a respondents. Static council PNRD permitted weeks time. It is instructed by the MSU Sharma for 3. Yes, up to 2 weeks.
Like,
In this case, notice was issued on 4th of December 2024. We are challenging the issuance of de novo inquiry, even after inquiry is submitted that in favor of me. So affidavit in opposition is need to be filed. They have not filed the affidavit.
Well, I need 3 weeks time. Last week.
Mr. P.P. Dotto for the petitioner, Mr. D. Gugoi for the forest department. Mr. Gugoi prays for 3 weeks for the time. Complete his file with the DF. It's made in the law.
Public.
It's after 3 weeks.
Lordship, along with Lordship, it petition number 6970 is a similar matter.
Where is it?
Lordship, to take with.
You make a mention on the next date for being listed together. That order will have to be passed on the petition.
If Lordship, okay, I will do.
The matter is not before the court.
Yes.
You'll have to pass an order in that petition. Also, connect it.
Lordship.
Public.
shift some more time may be given to.
My lord, pursuant to my arrest, my lord, I was suspended, my lord. Today is 11 months, 28 days, my lord. They have neither reviewed nor revisited the order. No any recent order has been passed for extension of my suspension, my lord.
What about departmental proceeding?
My lord, that also not started. No charge sheet is filed in the criminal case. No departmental proceeding, my lord. This, my lord, just open and shut case, my lord. They can bring instruction, my lord. Because they have not renewed that, my lord. I have not served any copy.
Yes.
Shift some time may be given,
How much time?
3 weeks.
Why 3 weeks? Just to find out whether you have reviewed or not.
Yes, my lord. Simple, my lord.
Why 3 weeks? Get it by next Wednesday. 4.
Obliged, my lord.
List on board,
Nice.
using the council for the PNRD to complete his instructions in the matter.
Right.
Milord, an affidavit in opposition on behalf of the university is being filed today, Milord. It's under process, Milord.
Mr. M. Sharma for the petitioner, Mr. P.J. Bhuvan, Standing Counsel,
KK Hendik,
K.K. Hendik,
State Open University.
State Open University, submits that the affidavit in opposition on behalf of the university is being filed today
Today.
during the course of the
My
day.
lord, if I pray for a date after
With the
4 weeks,
matter.
my lord,
Do you-
we'll need to file a reply to the affidavit as well. My lord, fixed date, my
Let the matter be, why fixed it?
lord. My lord, the issue here is that the petitioner's salary has been refixed.
How much time would you require to file reply?
They filed the reply, they filed the affidavit today, my lord. Just as an abundant caution, my lord, take subject to your lordship's convenience, maybe 3 weeks or 4 weeks, subject to your lordship.
So if it is 4 weeks, then why do you want a fixed date?
No, my lord, in fact, the date, the matter with
List after 4 weeks, we'll give you 4 weeks. You make a mention once you file your rejoinder.
I'm grateful, my lord.
Most of that matter be listed after 4 weeks, enabling the petitioner to file the rejoinder. Enabling party to exchange their.
Yes, look at this, section 11 application, the respondent is yet to file the response to that.
Yes, but I have received some instruction from the executive engineer, but in this case, instruction from the government is required for. So I am praying for some time. 3 weeks time.
Already they have taken time and application.
You are filing objection.
In fact, Lordship, one arbitrator has already been appointed. They are praying for replacement of him by.
Not a replacement as that. Not a
Yeah.
replacement. Not a replacement. I'll just place the facts. What has happened is, your lordship, initially an application was filed by us seeking appointment of an arbitrator, and they had appointed a particular person as an arbitrator. Then the claimant raised some objection with regard to his impartiality. And the arbitrator concerned issued an order and resigned from the post. Now, initially there are, as per the contract agreement, there are two options. Either it would be a sole arbitrator or a three arbitrator. So initially the sole arbitrator process was initiated by the respondent, and a particular person was appointed. During the course of the proceeding, the claimant felt there was something amiss, and he filed an application regarding the misconduct, alleging some misconduct. The arbitrator passed an order saying that as that question has been raised, he wants to withdraw from the case, and the arbitration proceeding was closed. Before we could,
That was by the sole arbitrator.
that was the sole. Before we could file our second application seeking reappointment, they've changed the system. They appoint that particular person as their nominee arbitrator in a three arbitrator panel and ask us to make appointments from a panel list. No list was furnished to us. And that particular person who himself has withdrawn is now made a nominee arbitrator by the respondents themselves, changing from the scope of a single sole arbitrator to a three arbitrator.
What does the arbitration clause say?
Arbitration clause, your lordship will find at page,
Provides
it
for
would
three
be page 100 and, sorry, it would be page 120, clause 20.
three arbitrators.
Yes.
So they have already appointed one.
Appointed, but it is either a sole arbitrator or, because initially the process started with a sole arbitrator. The priority was a sole arbitrator. And the person whom we had objected to and who had already withdrawn on the ground that some questions had been raised is now again being nominated by the respondent as their nominee arbitrator. Your lordship will find, if page clause 20, if I may be permitted to read.
Initially, it should be sole arbitrator.
Sole arbitrator with both parties. If it is failed, if they fail, then the three arbitrators. Here, there was no option of failure, Your
Where is the order of the arbitrator?
Your Lordship will find the order by which the arbitrator resigned. Your Lordship will find annexure X, page 209, and the operative part, Your Lordship will find at page 212. It is on the application filed by us, and he has said that finally, if I may, page 112. It is a long order. Finally, the arbitral tribunal feels that as the claimant has no trust upon the arbitral tribunal and raised many unpleasant and unwarranted comments upon the independence and impartiality of the sole arbitrator without any justification, doubt before the submission, and hearing of the AT further constitute proceeding may lead to more controversy and dispute. I therefore terminate the proceeding here and close this arbitral such and such through this appointment letter such and such. So this was done. And the particular person, Your Lordship will find at page 213, he was the person who was appointed. Now again, this same person has now been appointed at page 220, annexure Z3. Interestingly, that order was only sent to us by this particular covering letter of the respondent themselves, and that too through a WhatsApp message. The hard copy, we downloaded it. Page 220 at Z3. If I may read out, with reference to above, it is to inform that in response to your petition number dated 9/4/24, hearing of the arbitral tribunal was heard on 4/5 in the conference room of the undersigned, where the arbitral had discussed the various complaints and issues raised by you, and formally terminated the arbitration proceeding and closed the arbitral tribunal after rendering his view and comments by this letter. That is the particular letter I had read, Your Lordship. Consequently, in view of the same as per clause such and such of the tender agreement, it is proposed to constitute an arbitral tribunal consisting of three arbitrators by appointing such and such, the former such and such, as an arbitrator on behalf of the department. Accordingly, you are required to appoint an arbitrator from the empanel list of arbitrators to represent the contractor in the consisting of three arbitrators. So two things are there, Your Lordship. The person who resigned, he has been reappointed. Secondly, the list itself has not been forwarded to us as of date. And once we had raised a doubt with regard to that, whether that particular person, the respondents knew about that, and this order was never communicated to us. It was through this particular covering letter, this order of his withdrawing had been sent to us. Even prior to receive of this letter, we had already sent a request for a sole arbitration again. And that particular letter, Your Lordship will find.
Now, are you proposing to nominate your arbitrator?
No, I'm not proposing, because the sole arbitrator was the norm. We had not agreed to it. There was no dispute with regard to non-agreeing to a particular sole arbitrator. They have directly shifted the the constitution of the arbitral tribunal from a sole arbitration to a three arbitrator panel, and have asked us to nominate. But we have not been even given a panel list also. And the clause
So
clearly says.
you're essentially praying for the direction to appoint the sole arbiter.
Yes.
You want some time.
I think they want some time.
I want some time, but the procedure is clear, section 13. If you have any objection in respect of engaging in a sole arbitrator law, and where to go, where to lodge the appeal law, before this honorable court or before the tribunal?
The tribunal has terminated the proceeding.
No, Lord, in the next tribunal law, if we have appointed from our side, we have appointed one.
That
now they are required to engage their one. Lord.
No, we'll have to decide that.
Lord, in that case,
once the tribunal, see, your clause says sole arbitrator. If you don't agree, then go for three arbitrator. So the sole arbitrator was appointed, it proceeded for some time, and then the arbitrator terminated the proceeding
As a sole arbiter.
as a sole arbitrator.
Now we are going for three arbitrators.
No. Subject to what happened. See, therefore the sole arbitration, the clause prima facie says you agree on one. If you can't agree on one, then we go for three. Will it be sufficient to, will it include a meaning that you agree on one, proceed in the proceedings and the proceedings get terminated and then you go for the three arbitrators?
Yes,
Or
Lordship, subsequently we have nominated one. They are not agreeing to him, Lordship. So they will appoint one on their behalf,
no,
Lordship.
no, no. Once the proceeding terminates,
Yes.
do you go to the next clause or you come back to the earlier clause and redo the whole process? That's the question, I think. You
That
file
is
your
the
response.
concept.
Let the respondents file their actions within 3 weeks. May Mr. A. Viswas for the petition does not object to prayers after 3 weeks.
Obliged.
But Mr. Biswas, there's another question you'll have to deal with. When the agreement says 3 arbitrators, can we appoint one?
That issue is there, but here the option is,
This,
we have not,
this is divorce the option which you have raised.
yes. Understand,
Your grievance is that sole arbitrator, only upon failure go for 3.
Okay.
So sole arbitrator proceeded, then it got terminated. Does it automatically go to the next clause or you come back and redo the whole process from clause 1?
Because we had not refused on the issue of a sole arbitrator. The issue is not, because I had exercised my right under the Act against the sole arbitrator. I had not per se rejected the formation of a tribunal
All right.
of a sole arbitrator.
But what we want to know is assuming,
Yes.
assuming we answer question 1 against you,
Yes.
then we go to the next question.
Yes.
In the next question, there are 3 arbitrators.
Then your lordship will have to ascertain when a person has been, because I will again have to raise a query against that particular person under section 16, your lordship, with regard to him already having expressed that he is impartial, that position is there. If it would have been any other person apart from that, that would have been a different thing. And secondly, your lordship, as per the various apex court judgment, panel list has to be the entire list. It cannot be selective from them. They select 3 persons and sends to the claimant, saying that you select from these 3 persons. The list person means the entire panel list has to be furnished to the other side. It cannot be pre-selected. Here, they have only mentioned from the panel list. Till date, that panel list is yet to be furnished to us. So the question is whether, on one hand, they have so unilaterally changed the issue of a sole arbitrator to a 3 arbitrator when there is an application, second application by us seeking appointment of a sole arbitrator.
All right. Let the objections be placed.
Obliged.
There are papers from time to file my application. Waiting instruction.
Any objection?
Lordship will pass over the matter for time being.
He's praying for 3 weeks' time to file affidavit.
Instruction.
Counsel, Mr. S.S. Roy for the CTC prays for 3 weeks' time to complete his instructions. Counsel for the petitioner does not object to the prayer made list after 3 weeks.
That the deduction was not, and I have contacted the petitioner counsel also. He was no longer in the case, he told me. Free. The deduction is not there.
He is no longer in the case.
No longer in.
Deduction has been
Not with me.
not mailed.
Not made it. From the last salary certificate, we have picked it up. The deduction was not. I have asked the, if I have taken back the brief long back.
Then we'll have to issue notice again. Petitioner is the employee.
Yes.
He is putting to challenge the show cause notice.
Focus notice, therefore, we have asked him to deduct. As
You have not deducted it.
Will not deduct. But last salary certificate was enough. Because there are some family disputes that are pending before the. They say without that, we cannot deduct.
Right, we'll just pass it over till next week, item 3. Item 3, next week, it is none appears for the.
That relates to non-payment of monthly salary of the prisoner also. He's working as a surveillance worker on the Malaria Department of Autonomous Council.
Yes,
Lordship may kindly grant us 3 weeks time. Seek instructions and file a
any objection?
Second thing, he's without salary, though. Areas may be directed to be paid for.
We'll give you 2 weeks. Get your instructions in 2 weeks. Heard Mr. D. Burwal and told that getting behalf of AAC. Raise for 3 weeks time. So, since this is since the petitioner is only court praying for release of salary, let the matter be listed after 2 weeks, by which time the respondent will complete their instruction. Must be list after 2 weeks.
May this lordship, my lord, here I pray for 2 weeks time to file my reply.
Counsel for petitioner prays for 2 weeks further time to file reply evidence. Prayer made without list after
Okay.
2 weeks.
Right, yes, my lord.
Yes.
In the present case, my lord.
Huh?
For the temporary benefit, my lord, claimed by the present petitioner being a second wife, my lord.
You are the second wife.
Yes, my lord.
My lord, I'm for the private respondent number 7.
First
Could you
wife.
kindly have a look at the last order dated 12/2020.
Private respondent 7 is who?
My lord, actually, my lord, I am the second wife. My lord, first wife already did. On the death of first wife, my lord, I was married. Then he came that claimed to be a second wife, my lord. That is not true, my lord. My lord, kindly have a look at the order dated 2/12/2022, para 3, my lord. This honorable court has already recorded his date of marriage and my date of marriage. He was married on 23/1995 and I was married on 6/8/1990. Then, my lord, the subsequent paragraph, the court held that I being the senior, I should be payable the response, my lord.
not the petitioner. Then, my lord, he also claimed that she has a daughter, through her husband, the Solomon Khandagar has a daughter through the petitioner, and this court has directed that why the respondent, my lord, respondent 7 should pay. My lord, in that connection, my lord,
You were supposed to inform the court.
Yes, my
isn't
lord.
it?
Yes, my lord. To that effect, my lord, I have filed an affidavit, my lord. Lordship, I have filed affidavit on October 24, and I have enclosed some documents which goes to show that that daughter has been already married, my lord, and she had delivered a child. That birth certificate I have annexed, my lord, in the affidavit. I have annexed a certificate from Gabura that she is already married. Then, my lord, the birth certificate, at least, my lord, disclose that she is married. She has husband, Imdadul Ali, and delivered a child. So, my lord, under that position, my lord, the petitioner's daughter is also not entitled to maintenance, my lord, and they have not filed any reply to this.
Now, all right. What about the petitioner?
Petitioner, my lord,
Entitlement.
this order, my lord, the order itself indicates that I am the person to receive the pension. He is
You
not.
are, but you will receive it in your capacity as a trustee.
My lord.
The order is also clear, plus read with the full bench judgment.
Yes, full bench judgment says, my lord,
You
even if, my lord,
in the capacity as a trustee.
trustee, I am in the capacity of trustee. But my lord, my lord, if subject to condition that if marriage is valid marriage, and then, my lord,
What is it?
and if he is not satisfied,
Raising the objection. Is the ground for raising the objection of a valid
my lord, according to us, my lord, actually, my lord, the documents which they have annexed in the writ petition, that there was a dispute with the petitioner and Solomon Khandagar, and to that extent he approached the court, and court has given some amount, 1,30,000.
Where is do you have a marriage Kabin number?
No, my lord.
Tell.
I have only marriage certificate, my lord. Lordship may
Where
want
is
me
the
come
marriage
to-
certificate?
Lordship may want me to come to page 28, my lord.
28.
Yes, my lord.
Yes.
After the husband of the petitioner deceased, my lord, died, my lord, expired, the SP write a WT message, my lord, to the PS officer in charge of Mankasar PS, my lord. To here is written, my lord, the so and so, this office so and so, dated so and so, registered inquiry about the legal heirs and the next of kin of the deceased so and so, so and so, so and so, my lord, who was expired 30/8/2020 at about 9:40 p.m. for prepare of the family pension test. Now, Lordship, my lord, in response to this, my lord, WT message, my lord, Lordship may come to page 30, my lord, 30. The officer in charge of Mankata police investigation investigated the matter, my lord. He forwarded this report, my lord, page 30, to the SP Gwalpara, my lord. Where is, my lord, number 1? This is the petitioner name. Number 2, this is the respondent number 7, my lord, and the other hairs, my lord. Is their report, my lord. I am one of the legal hair.
My lord, either it can be a valid, authentic information.
So if not, then you will have to show from your documents that.
My lord, I am the the second wife. He is not the second wife. He is the third wife. My lord, as per his claim. My lord, and
Next slide, my lord.
On what basis are you making this
my
claim?
lord, my lord, kindly have a look at my affidavit. Affidavit annexer.
Then this is a, you see, who's receiving the pension now?
My lord,
Response number 7, my lord.
Huh? Why? On what basis? Where is that? Where is the next of kin? Who submitted? Department. Department took up next of kin certificate.
Lordship make.
my lord, kindly have a look at
Next of kin certificate, my lord.
Wait. Huh? Who submitted next of kin?
My lord, response number 7 might be, my lord. We also submitted, my lord. We also submitted next of kin certificate, my lord. That was not considered, my lord.
Who is Rashena Khatun?
That is the.
So this next of kin certificate is
Yes,
there.
my lord. I have also, my lord. Lordship may come to page 26, my lord. Of my.
26.
Yes, my lord. Next page 27, my lord. All the next of kin's name are appeared. My lord, Lordship, may I, my lord? One submission, my lord. My lord, what happened, my lord? The petitioner is the original resident of Mankasar, my lord, South Salama district, my lord. This next of kin is issued by the office of the Deputy Commissioner, South Salamara, my lord. And that my learned friend referring the next of kin certificate issued by a Deputy Commissioner of Gwalpara, my lord. At that time, while the husband of the present petitioner was expired, my lord, and then he was working in Gwalpara, my lord. My lord, he is the original resident of the Mankasar, my lord. That's why the next of kin certificate issued by the South Salama Mankasar district, my lord. It is on page 26 and 27. Whereas my name is appeared in till number 1, my.
Yeah. Are you disputing this certificate? Next of kin? Yeah.
I'm the only wife.
Where?
I look at page 12 of my
Uh,
affidavit.
declaration before a notary.
Yes.
What is the value of this?
First,
What is the evidentiary value of this? What is the evidentiary value of this? Is the declaration?
and accordingly, the
Oh, you have to challenge this next of kin certificate. It is enclosed to the writ petitioner, saying that to say that this is not authentic. Not given, you have to ask for it. You did not point out until now. You give him a copy.
Yes, my lord, sure, my lord.
Today itself.
My lord, today itself.
You have to dispute that His client is not married to your late husband.
Even my lord, in the year of before the expiry of the husband of the prisoner, present prisoner my learned friend also referred that case, my lord, file a maintenance case, my lord. That
Who filed the maintenance case?
present petitioner, my lord.
Ah.
And lordship may come to page 22. Lordship may- Page 20, my lord.
What is your name?
My name Minara Bibi, my lord.
Minara Begum.
Yes.
Page 20.
20, my lord. Who's it?
What is the status of this case?
My lord, this is settled, my lord. The husband of the present petitioner at that time paid 1,30,000, my lord. Accordingly, case was withdrawn, my lord. Page 24, my lord. Order, my lord. Page 24, my lord. Again, subsequently, my lord, the petitioner also files a DV case, my lord. During the pendency of this DV case, my lord, his husband expired.
Where is the settlement? Is it on record?
My lord, it is outside the court.
No, but nothing is filed.
Nothing was.
Nothing is filed.
No.
Then there is no Kabinnama.
There is the marriage certificate, my lord. Which is on page 18, my lord.
1-8.
1.
He should have elect them as parties. How will we verify? Who will verify this record?
My lord.
Who will verify this record? Who's for the Home Department? Yes. Hmm. They have already verified para 4.
My lord.
Para 4
My
of
lord.
the affidavit.
Yes, ma'am.
They say that there is no such document. Then
My lord.
you think about it. We'll come back.
My lord. Lordship may, again, my lord, I am.
We may issue a warrant for falsification of document.
Lordship. Now, the coordinate based on this on our port, my lord.
The coordinate bench of this honorable court while passing the last order, my lord, what Lordship was referring, my lord. On that day also, my lord, same question was raised by by the Lordship was, my lord. My lord, on the basis of my submission on that day was that, my lord, this document was provided, given by the friends of the present petitioner, my lord, after our marriage, my lord. Petitioner being bona fide belief on her husband, keep these documents, my lord. My lord, petitioner has no intention to mislead this court, my lord. Lordship, I am referring another documents, Lordship. Once may come to, my lord, page 19, my lord. Page 19. This is the registration certificate, my lord. My daughter, my lord. Where, my lord, last part, my lord, father's name and mother's name both are appeared, my lord, recorded.
No, there is an averment in the affidavit filed by the department that this certificate is not genuine.
Yes, my lord.
Yes.
That affidavit was taken into consideration on the last occasion, my lord.
Oh.
Then the, my lord, that order was passed, my lord.
Which order?
My lord, Lordship referring 212 might be, my lord. Well, 2022, my lord. Yes, my lord, 212 order, my lord. Right, my lord.
Isn't it the Khandakar? I'm sorry, Sikdar. Where is Mr. Sikdar?
Might be in court number 6, my lord.
Mr. Sikdar.
Yes, my lord, it might be in court number 6, my lord.
Will I call him? Take it up in a while.
My lord.
Here, Sikdar.
Please, your lordship. My lord, petitioner was enrolled in the year 2011, my lord. He has completed 11 years of service, my lord. But 31st of July 2021, he was invalidated out of service, my lord, placing him low medical category, my lord. My lord, kindly see Annexure 1, page 18, my lord. Annexure 1, page 18, my lord. His invalid medical board was approved by the authority and he was given an opportunity to take, my lord, certificate from the civil surgeon if he is not satisfied with the findings of the medical board. That is, my lord, as per rule, he is entitled. This opportunity was given to him, my lord. And accordingly, my lord, he has taken, my lord. Kindly see Annexure 2, page 19. He has tested himself, my lord. Everything is in normal range, my lord. Then, my lord, Annexure 3, page 20, my lord. He has taken certificate from Guwahati Medical College. And certificate says like this, my lord, this is to certify that Suresh Kumar, 35 years, male, is physically fit and at present he has no any problem, my lord.
What was your medical ailment?
My lord, medical category initially placed 2, my lord, then 3, then 5.
Why?
Because of, my lord, they have said ADS, but that is, my lord,
88.
ADS, my lord, alcohol dependence syndrome. My lord, that was not proved, my lord. However, I am today not on that because as per rule, I am, my lord, I have submitted all this document, my lord. Then again, they have said, Annexure 4, page 21, they have said you bring the document in Appendix D, my lord. So I have taken this certificate, my lord, pro forma certificate to be produced by the appellant, challenging the finding of the medical board, requesting for review because I have requested for review medical board because I was not satisfied. Then my lord, kindly see, I, Dr. So-and-so, certify that I have examined Suresh Kumar, age 35 years. After careful examination and investigation, it is opined that he is not suffering from any disease. To arrive at this decision, I have examined the relevant medical documents and conducted necessary investigation. Then, my lord, I have submitted all these documents. Then, my lord, these all I have to produce within 30 days as per law, my lord. Annexure 5, my lord, when I have submitted, they again return me saying that you submitted as per letter 6 May. That is Annexure 1 I have already shown. Then, my lord, again I have went to during Corona pandemic, my lord. I have again Annexure 6, page 23. I have went to RIMS, my lord, but somehow I have again taken certificate where it is said that, my lord, I have no any psychiatric disease, my lord. Then Annexure 7, my lord, page 24. Again, I have given certificate by the RIMS hospital, my lord. I, Dr. So-and-so, I have examined Sri Suresh Kumar, age about 35 years of this, and due with ADS, after careful examination and investigation, it is opined that he is not suffering from any ADS. To arrive at the decision, I have examined the relevant medical documents and conducted necessary investigation. Then, my lord, after that, my lord, they have not, my lord, taken all these things. Annexure 9, page 26, my lord. Relevant page 27, they have discharged me because of invalid, as I am invalid, my lord. And my lord, then next annexure, my lord, page 10, annexure 10, page 31, relevant page 32, my lord. This is the rule, my lord. Rule 26, my lord, may I read? Page 32, my lord. Retirement or discharge of subordinate officer and enrolled person on the ground of physical unfitness. Where a commandant is satisfied that a subordinate officer or an enrolled person is unable to perform his duty by reason of his physical disability, he may direct the said subordinate officer, as case may be brought before a medical board. The medical board shall consist of such officers and shall be constituted in such manner from time to time be laid down by the Director General. This is relevant, my lord, where the said subordinate officer or enrolled person is found by the medical board to be unfit for further service in the force. As the case may be, the authority as specified in Rule 17 shall, if it agrees with the findings of the medical board, communicate to the person the findings of the medical board, and thereupon, within a period of 30 days of such communication, the person may make a representation against it to be competent authority, supported by a prima facie evidence of error of judgment in the opinion expressed by the medical board. Such an evidence should be from a government doctor, not below the status of civil surgeon, and should contain specific mention that he has taken the consideration of the medical board matter. This is my simple case, my lord. They have not taken this into account, man. And my lord, I was discharged from service. My humble submission, my lord, I may be again, my lord, given a chance of review medical board, my lord. As per law, I am entitled. I have during Corona pandemic also within that time, only 2 days late, my lord, from Imphal to my lord.
What is there stand in the affidavit?
There's then, my lord, that I have certificate. I have made that certificate. First of all, I have not placed in the appendix D. Then I have taken. Then they have said that you have not taken the from psychiatrist. I have taken from psychiatrist. Then they have said you have not filed the certificate within exactly 30 days. 2 days late, my lord, because of first they have issued me 6th of May, my lord. Within the 2 days late, my lord, because of Corona pandemic, my lord, 2021. My lord, I could not have it within two days late, my lord. So this way they have rejected my all these certificates.
Yes, Mr. Goswami.
After rendering 11 years of service, my lord, this simple opportunity which is permissible as per law, my lord, I am entitled. So I am paying for this honorable court, my lord, for review medication.
Yes, Mr. Goswami.
Both here, the of the department about particularly alcohol dependent syndrome. About this is something from that.
in our affidavit, my lord, paragraph, my lord, is 6, Roman paragraph 5, my lord. Based on the opinion of the, my lord, invalid medical board, that is Annex 6, case, my lord, 63, my lord. Yeah, read, my lord. Behavior report dated 4/3/2021. And describe individual as uncontrolled drinker and below average in professional competence with follow-up alcohol status as not abstain or worthy. To describe his compliance with treatment as unsatisfactory and further his retention not recommendable as the individual was become an unacceptable liability to the organization. But the history of presenting illness, this 35 years old young soldier of Assam Rifle, general duty by trade, who was earlier upgraded to SI during July 2019 for alcohol dependence, has been referred by AMA in an intoxicated state. He was found abusing alcohol at transit camp and presented with chest pain and so was a hence referred. He had consumed 1 full bottle of hard liquid. Detailed detailed evaluation and perusal of available medical document reveals that individual has been abusing alcohol soon after arbitration and rapidly developed the tolerance and withdrawal and on attempted abstinence and loss of control. Condition on the present admission and course in the hospital. On admission of the individual was intoxicated, there was smell of alcohol, but some speaks and not cooperative. He was initially detained in emergency on so and was admitted on so. He was later on hold.
Now,
Started
he's
for
entitled,
Spain.
he's entitled to submit
Malad,
opinions.
Malad, our stand in the affidavit is that Malad, he produced initially a document, Malad, but that was not in accordance with the Malad rules, Malad. Initially, whatever he has submitted a document from the GNP doctor, that is not the secretary, but it's a document certified by an.
Why don't you accept it now and go for review, pass your order?
That is not admissible. That is why rejected because not the secretary doctor has issued that nothing that certificate. It is issued by a general medical practitioner, the medicine specialist. Initially, subsequently he produced a RINS info. It's a different matter altogether. But at the time of relevant point of time, he has produced some relevant document, medical certificate.
So consider the subsequent document. Reconsider it and see. You reconsider and pass appropriate order.
Wow.
Where is the subsequent one? Page number?
Oh my God.
Let's read further.
Annexure 6, page 23, Annexure 7, page 24.
This is by Department of Psychiatry. RIMS.
Yes, ma'am. This is annexure 4, page 21.
And then
Then, my lord, annexure 6, page 23. Annexure 7, page 24. All I have taken within 30 days, my lord. First letter is to
no, 23 and 24 are issued by RIMS.
Yes, ma'am.
Why two certificates are necessary?
No, they have said, my lord, take one from medicine, one civil surgeon, one psychiatric. Whatever they say, my lord, I have given everything.
23 is psychiatry. 24 is also psychiatry.
This is, my lord, Regional Institute of Medical Science and
It is as per format.
format, annexure.
Annexure
appendix
7 as
D.
per format, because
Appendix D,
the
my lord.
annexure 6 was not as per format.
Appendix D is written in my right hand top. They have said you bring on appendix D.
When was annexure 7 issued?
It is 3rd of June, my lord. Left hand side bottom, 2021.
So according to the respondents, page 23 is not as per format. Mr. Goswami
Not as per format, that is why they
did not consider.
in fact, initially, annexure D, page 21 was submitted. It is not from the psychiatric department, it is from the medical officer, civil surgeon.
Hmm.
That cannot be acceptable.
Very well. Then 23.
23, that is by the psychiatric department. Our stand, that not as per the format, because the initially it was as per the format. Subsequently, in annexure 7 document is as per format, annexure appendix B format.
But it is beyond 30 days.
Well,
So you consider recent person?
2 days, my lord. Day 9 June I have submitted during Corona pandemic, my lord. First letter they have
Was
issued.
any order passed rejecting this application?
No.
so since it was beyond the stipulated time period, it could not be taken into
You
consideration.
consider it. When was
The prescribed
number-
time limit is 30 days.
page number 21? When was it submitted?
Yeah.
21 and 23.
15th of May, my lord. They kindly see an annexure 5, page 22. Page 22 they have written. Para 2 submitted on 21 May.
Our stand in the paragraph 13 of the opinion opposition model. Beyond 30 days time as per rule.
Where is your
26
government?
of the Assam
When did you submit it? Writ petition, where it is stated?
Page my lord, 11, para 18. Report date also para 16, 17. May I read, my lord? 2 days late, my lord, para 18. Petitioner begs to take there. He was supposed to report 44 Assembly number 7.
Page number 21. When did you submit? Which paragraph have you stated? Paragraph 14.
Well, I have submitted on my lord 22nd of May, my lord.
I heard the counsel for party. Petitioner before this court. Was employed. Was serving as Constable GD in the Assam Rifle. You're Constable GD,
Rifleman GD.
Rifleman GD. Assam Rifles. Because of his medical status being brought down to lower medical category, namely S5, he was invalidated out of service with effect from 31 July 2021 by the order number 12 dated 18 June 2021. So, the grievance of the petitioner is that pursuant to the order of the respondent invalidating petitioner out of service on no medical ground. As per the rule, petitioner was entitled to submit independent medical evaluation obtained from government doctors, specially to seek a review of the orders of the respondent in the event the petitioner was aggrieved. It is submitted that in terms of the rules, in terms of the provisions, the petitioner submitted before the authority the medical certificate dated 15/5/2021, which was obtained from the registrar, Departmental Medicine, EMCH. The said document was refused to be accepted by the respondent as the petitioner was invalidated out of service because of alcohol dependency syndrome within bracket ADA, and therefore a appropriate certificate, if furnished, can be considered. Therefore, a certificate from the appropriate specialist / department, if furnished, can be considered. Named Departmental Secretary. The petitioner thereafter furnished another certificate from the Department of Psychiatry, Regional Institute of Medical Science, with the bracket RIMS, Imphal, Manipur. So it is submitted that as per the said certificate submitted by the senior resident as capital Arcade, Department of Psychiatry, RIMS, Imphal, the no psychiatric disorder was found present in the petitioner, and further there is and further it was certified that the petitioner was not taking alcohol currently. So this certificate, however, not being in the prescribed format, was refused to be accepted by the respondent authority. Thereafter, the petitioner again submitted a proper certificate in the prescribed format from the senior resident, Department of Psychiatry, RIMS, ID certificate dated 3/6/2020. It is submitted that as per rules, the certificate for a review of the order of invalidation was required to be submitted in 30 days. So, petitioner was invalidated from service on which date?
51 July 21.
31.
July, page 27.
You are required to submit 6th of May 2021. And as such, the petitioner,
6th of June. 30 days.
this page number 18.
Yes, this is after this 30 days.
Where is that order?
Annexure 1, my lord, is 18.
Annexure 1 is 6th of May.
Yes,
This is the order of invalidation.
this is, my lord, you have to submit within 30 days from this letter. This is 6th of May. Then I have to submit 6th of June within.
The petitioner was informed annexure
15, Roman 15.
in your affidavit.
Well,
Page number.
there's no history developed grandmother before. Eventually, there's none of it.
Petitioner was informed of the respondent department or decision to invalidate him out of service because of low medical category. And he was permitted by necessary application with degree requesting for a review. So this information was this was intimated to the petitioner by communication dated 6th of May 2021. Although the certificate of the appropriate department, namely the Department of Psychiatry, obtained in appropriate in the prescribed format, dated 3/6/2021, was received by the petitioner, but by the time he submitted the same, the respondent authority period of 1 month had expired. Subsequently, the respondent declined to accept his prayer for review, and by order dated 18 June 2021, petitioner was validated after. Where are the counsel to the petitioner submitted the related prayer? The petitioner needs to seek direction from the court to consider a case for review, as the delay that had occurred in submitting the certificate in the prescribed form was unintentional, and it was during the COVID-19 pandemic period, and which had contributed to the delay in submitting the application seeking review, supported by appropriate medical documents. So, whereas the respondents have contested the claims of the petitioner by filing their affidavit. So, the journal seeks submit that the first application, the first certificate submitted by the petitioner was from the Department of Medicine, or DMCA, and which department is not the appropriate department to certify in respect of the health status of the petitioner who is suffering, who was brought to low medical category because of ADH, ADS. The subsequent certificate submitted, subsequent certificate of the Departmental Psychiatry from RIMS was not submitted as per the prescribed format, and therefore the same is not accepted. So, the certificate again from RIMS, Departmental Psychiatry, dated 3/6/2021, having been submitted after the expiry of 30 days from the date of issuance, date of receipt of the letter, dated 6th of May 2021. The case for review was not considered. Counsel for the parties have been heard. It is available on the court. Peru. So, it is seen from the pleading that the petitioner is in possession of certificate from the appropriate department, namely Department of Psychiatry, RIMS, regarding the evaluation in respect of his health state. So, the certificate from the certificate see that the specialist had certified that the petitioner is, is not taking alcohol currently. Whether such a situation will invite the review and thereby the case of the petitioner can be reconsidered with respect of his invalidation out of service to medical category, will require consideration of the act of the respondents. So, the communication dated 4th of May 2021 clearly reveals that the petitioner may make a representation within 30 days from the date of receipt of the letter. So, the said communication was issued on 6th of May 2021. When did you receive it?
6 May.
You received on 6th May.
Yes.
You say according to the petitioner, the same communication was received on 6th of May 2021. The certificate which the petitioner is relying on and which has been issued by the RIMS, Departmental Psychiatry, in the format prescribed in the certificate dated 3/6/2021. So, this clearly reveals that the certificate was obtained by the petitioner within 30 days from the date of issuance of the letter dated 6th of May 2021. Taking into consideration the submission of the petitioner that during the year 2021, country was reeling under the COVID pandemic situation, and therefore the certificate cannot be submitted to the authorities in time. this court totally considered that the benefit, limited benefit in view of the COVID pandemic, which was it, is the engulfed the nation at the relevant point in time, should be granted to their petition. So the petitioner, you have submitted this no.
Submitted, my lord, they have rejected.
The petitioner will submit a fresh copy of the certificate dated 3/6/2021 issued by the RIMS Departmental Psychiatry within bracket and 7 page 24 of the writ petition, along with all necessary medical slash test, blood test report. To whom? To whom is it to be submitted?
The respondent number 3, respondent number 3.
Respondent 3. Within 15 days from the date of receipt of a certified copy of his the respondent 3 will review the certificate along with the medical document that passed a speaking order, and on the prayer made by the petitioner seeking review of his invalidation out of service due to low medical category. So the order directed to be passed by the respondent 3 shall be passed within a further period of how much time do you require? 1 month, 30 days from the date of receipt of medical certificate along with certified copy of this order. It stands disposed.
Highly obliged.
In the last occasion, my lord was pleased to direct us to produce the payslips and the petitioners where they are currently working. My lord, we have received a list from them, my lord. And if my lord allows, then we'll annex it in the additional affidavit, my lord, because it is not a type 1.
Right, madam, because
We
there
have
are
just
528 petitioners.
Yes, my lord, we have just written the petitioner's number here. My lord can peruse it, my lord.
No, you bring it on record.
Yes, we'll bring it on. And my lord wanted to see the pay slips, my lord, that we have.
Bring it on record.
Yes, yes.
Counsel for the petitioner submits that the pay slips received by the writ petitioner, pay slip of the writ petitioner as well as their current basis of proceeding have been received by them. They would like to bring it by their petitioner affidavit. So that is size we completed.
My lord, 3 weeks, my lord, there are 520 names.
Well, they will also disclose their appointing authority. Because they are contractual.
What is already in the petition, my
On
lord.
record, you want to object, you object.
Yes, my lord. And we have submitted our appointment orders, my lord.
We should not direct what they should include in the affidavit. Give it the liberty, whatever.
May I pay for a date, my lord, after 2 weeks?
After 3 weeks,
3 weeks a date, my lord. Need it.
you file it and make a mention.
Yes, my lord.
After that.
First we'll file. Deeply obliged.
Appears to the petition this next week.
May it please your lordship, my lord, petitioner is not given promotion according to his seniority because of ACR, my lord, lacking of ACR, that is uncommunicated. In their affidavit, they have clearly stated, my lord, it is not communicated. So, my lord, my humble prayer, my lord, may be disposed of because there are so many covered cases of this honorable court, my lord. I may be given an opportunity to make representation, my lord, to update my SCR, which is as per law, my lord, I am entitled.
Where have they stated?
My lord, page 22, kindly see annexer,
No, in their affidavit.
my lord. Oh, affidavit. My lord, kindly see page 44, my lord. Page 44, para 3.7. May I read?
Yes.
It is amply clear from the facts brought out in the preceding paragraph that petitioner was rightly superseded for promotion from Habildar to warrant officer in the DPC held on 2019 due to lacking of ACR. Para 37 of the ROI 597 provides that ACR will not be shown to the RETI concerned. Only adverse remark with points and below average figurative assessment in any quality that is will be communicated in writing in the form of a letter to the RETI. Petitioner was graded average 2 in the ACR for the year 2015 and 16 and recommended for promotion. Therefore, ACR for the year 2015-16 was not an adverse and same was not accordingly communicated to him. They have clearly stated, my lord, ACR for the year 2015 and 16 was not communicated
Yes.
to me, my
sir.
lord. So then I am deprived of that opportunity.
Not,
Is there any circular to that effect?
Yes.
Where is that circular?
53 and 54. Page 53.
Clause number?
Page 54 is the relevant portion of paragraph 4. Page 54, running page. The 7th Central Pay Commission in paragraph.
No, that is all right. The fact that you see, he got high average for 2 years. Up to page 43 of your affidavit.
I know.
High average. High average?
C. Serial number C, my lord. Average. 2 marks.
No, before that, high average for 2 years.
My lord.
And average for
Third year.
15-16. So, in terms of the law laid down, this is downgrading,
Right.
which may be and which may not be strictly adverse, but may have adverse effect. So you are required to communicate it to him before taking into consideration that.
My lord. But in case of military cases, military is my lord not required.
Where is that? What is this?
Paragraph 51. Can it start from 40, my lord? (41) We however make it clear that above directions will not apply to military officers because the position for them is different as clarified in this Court of Union of India versus Major Bahadur Sikh.
Yes.
2006-1 applicable.
Yes.
Lord, may I submit one thing, my lord? Assam Rifle is not military, it is paramilitary, and it stays under Government of India, Ministry of Home Affairs, my lord. So in case of Assam Rifle, they have to communicate it.
You'll have to hear it. You don't want to file rejoinder.
Reason, my lord, they have admitted and
Right,
so
right.
many covered
So the
cases,
party giving the topic is for admission hearing.
my lord.
Yes, Mr. Mazumdar.
My lord, here the grievance is twofold. One, the initiation of a departmental proceeding without the sanction of the governor after after retirement of the petitioner. And secondly, the withholding of his provisional pension till date, though he retired in the year 2017. But what has happened is, Lordship has page 16 for otherwise the law is settled. Their affidavit, in fact, their law is settled and their affidavit does not deny much in the petition. Page 16, my lord.
No stoppage without approval.
No, my provisional pension is not being paid even if we assume that a departmental proceeding can proceed against me at this stage after my retirement without the sanction of the governor, which was initiated without the sanction of the governor. Even in that case, my provisional pension was to be paid. That cannot be stopped. That has been stopped. Lordship would have paid 16, madam. But 27/10/2017, I was placed under suspension. By an order of the Deputy Commissioner Nagaon. Pending trial of departmental proceeding, so-and-so is hereby placed under suspension with immediate effect. An inquiry is conducted. Lordship would find at page 17.
Yes.
The last two paragraphs, I'll read the brief of the facts from the second paragraph. Charge of allegation against so-and-so was that he did not comply with the deceased order for updating the cash book and appraisal on the cash in hand amounting to dereliction of his duty. In this connection, see so-and-so was called for a hearing on so-and-so, wherein he was given a chance to speak. A written statement was also furnished by him, dated so-and-so, wherein he has claimed that he made some claims. Then, the entries in the cash book were examined by the Chief Accounts Officer and reported to have found correct. Hence, considering his verge of retirement an unknowing mistake, I wish to conclude that he has not derelicted the higher authority's order in sense of knowledge and belief. I, being the EO of the said DP, opine that the DP case of Sri so-and-so may be disposes for the welfare of the incumbent to avail all pensionary benefits. Page 18, the order comes. Here is the inquiry report submitted by Sri so-and-so into the department proceeding of Sri so-and-so, Nazar branch, Nagaon. Inquiry officer opined that Sri so-and-so is on the verge of retirement. Hence, he is warned and let off after having
What is the conclusion of the EO?
EO says entries in the cash book were examined by CA, a Chief Accounts Officer, and reported to have found correct. Hence, considering his verge of retirement an unknowing mistake, I wish to conclude that he has not derelicted the higher authorities' order in sense of knowledge and belief. So here, my lord, perhaps the inquiry officer is drawing a difference between an error and a misconduct.
And what is the order of the disciplinary authority?
Page 18. After considering all aspects of the case, the paragraph before that. Hence, he is warned and let off, having observed such kind of behavior first time for him and not to repeat in future. He is directed to be cautious in making himself available to duty and not to abandon it at will. After considering all aspects of the case, I so-and-so agree with the opinion of the inquiry report submitted by the inquiry officer, and accordingly, the incumbent is hereby reinstated in his original place of posting and directed to join immediately. The period of suspension is regularized as on duty for all purposes. That was on 4/12/2017. I retire on 31st of December 2017. Consequent to my retirement, Lordship will find at page 19 by 4/9/2018, my DCRG is released. The middle paragraph. His last emolument and qualifying services more than 25 years. Hence, proposed DCRG will be so-and-so. An amount of so-and-so only DCRG will be reserved for unassessed liability, if any. Therefore, proposed DCRG of so-and-so 6,88,000 is released. On the next page, at page 20, the unutilized earned leave is released. Then at page 21, my GIS is released, all on 4/9/2018. Since I am not paid my provisional pension, I make certain inquiries. On page 22, the Deputy Commissioner now states, whereas for processing pension-related works in respect of, that is the petitioner, have been sought from the concerned branches where he previously served. Whereas peruse the letter of the additional deputy commissioner, wide number, lordship will find it is of 2021, informing that the exact amount of liabilities in respect of Sri so-and-so pertaining to Nazar branch could not be ascertained due to anomalies in records. In this regard, statement furnished by the petitioner is found to be ambiguous and no definite conclusion could be drawn out. Moreover, reply from additional deputy commissioner regarding receipt and deposit of Bakijay collection money also reflects two different amounts for the same period. Whereas peruse the letter of so-and-so regarding non-realization of Bakijay, therefore, in exercise of Rule 21 of Assam Services Pension Rules, I, Deputy Commissioner, do hereby accord sanction to start departmental proceedings. The two things are obvious.
On the basis of the said inquiry earlier?
No.
No.
This
This
is
a
on the
fresh-
basis of a letter of 2021.
This is
At page 22, Lordship will find.
Where is that letter of 21?
My lord, I'm never served that. Now, 2021 letter, she sanctions the start of a proceeding. So this cannot be related back to a proceeding which existed at any point of time. It is a sanction to start a proceeding. Rule 21 is not to continue a proceeding. Rule 21 is to start a proceeding. And that has to be done by the governor. Is this settled law? No other officer can do it. Do hereby sanction to start departmental proceedings under Rule 9 against so-and-so senior assistant cum cashier. So this is one part which the petition is challenging, saying that Rule 21, resort to Rule 21 can be only by the governor to initiate a proceeding. Then, my lord, comes page 23. Is an order by which the enquiry officer is being appointed and the presenting officer is being appointed. Lordship will find that either page 22 nor page 23 talks of any statement of allegations as such, the charges or the list of documents and witnesses. Nothing is given to me till date. 23. In enclosing herewith a pro forma under Rule 9 of the Assam so-and-so, Srimati so-and-so is hereby appointed as enquiry officer to cause a thorough inquiry regarding allegation against so-and-so. Allegation made against so-and-so are as follows. Financial liabilities known to be there on the part of so-and-so. For the period, I do not know. So that even if we take it to be a charge, it is not specific. Objection raised, we do not know the date of the objection raised. Non-cooperation, while no objection certificate was being issued, we do not know when I was called for.
Yes. What is the respondent's view on
Now, respondents in their affidavits say, if Lordship would have yes, page, I read from page 29, para 11. I'm sorry, madam, page 31, para 15. Page 31, para 15. That with regard the statement made in paragraph 15 and 16 of the repetition, the deponent does not admit the same and states that the speaking order was issued for conducting a detailed inquiry, considering it as in continuation of proceedings drawn while Sri so-and-so was in service. Lordship, that page 21 that we read said to initiate a proceeding. As per Rule 21, the order was issued, and within Rule 21A, it is empowered that if departmental proceeding was instituted while the officer was in service, continuation of the proceedings after the final retirement of the officer shall be automatic. Pension. Rule 21, page 10. May I read, my lord? The governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery from a pension of the whole or part of any pecuniary loss caused to the government, if in a departmental or judicial proceeding the pensioner is found guilty of grave misconduct or negligence, during the period of his service, including service rendered upon re-employment after retirement, provided that such departmental proceeding, if instituted when the officer was in service, whether before his retirement or during his re-employment, shall after the final retirement of the officer be deemed to be a proceeding under this rule, and shall be continued and concluded by the authority by which it was commenced in the same manner as if the officer had continued in service. B. Such departmental proceeding, if not instituted while the officer was in service, whether before his retirement or during his employment, shall not be instituted save with the sanction of the governor of Assam. Shall not be in respect of any event which took place more than 4 years before such institution. Shall be conducted by such authority and in such place. Then Lordship would like to have Rule 22 for a moment. Rule 22(1) at page 13 of it. It says, where any departmental or judicial proceeding is instituted under Rule 21, or where a departmental proceeding is continued under Clause A of the proviso thereto, against any officer who is retired on attaining the age of compulsory retirement or otherwise, he shall be paid during the period commencing from the date of his retirement to the date upon which such conclusion of such proceeding, final orders are passed, a provisional pension not exceeding the maximum pension. But here what has happened is there was an inquiry report, it was accepted. With the acceptance of the inquiry report in whatever mean, by whatever mode, that particular disciplinary proceeding comes to an end. Final orders being passed on the inquiry report. So that inquiry having lapsed, the fresh inquiry is started after my retirement, admittedly by the Deputy Commissioner on her sanction, which is prohibited in law. The attempt of the respondents in an affidavit being signed by a person who is not even a party respondent in the petition, by a person.
So you say that it is hit by 21B1.
21B1. That it could not have been done
And
unless.
so the incident, when did it take place?
They do not speak of anything. Lordship will find that allegation.
That order.
Yes, 22 or 23. 22 is the order initiating it. 23 at best is the statement of allegation.
The order by which it was closed.
Closed. At page.
Now, if you come to page number 17.
Yes, madam.
This is the inquiry report.
Yes.
4.
Serial number 4 if Lordship has. When by August 2017 he was directed to show the whole cash book along with the some relevant things I could not show. So the discrepancy is in August 2017 or prior to that, whatever has happened. Show cause coming at page 23 in November 2021. It's beyond the 4 years. Any view of the matter, this proceeding is liable to be quashed. If it needs a hearing, even in that case, if it proceeds, even then, my lord, the provisional pension has to be paid, and Lordship will look at the conduct of the respondents. They have cleared my DCRG, which is not supposed to be cleared. They have cleared my EL, they have cleared my GS, they have cleared my everything. Therefore, leading to the conclusion that the inquiry was closed and therefore everything else was released. They could have withheld all of them as per the law. They release it. Now they say, I will not pay you provisional pension.
Yeah.
Worship, fundamentally, the DP has been started before his retirement, and there is an order. Then comes the Rule 21. Rule 21 says basically when it is in continuation of the DP and in the middle, if the person retires, so it may be treated as continuation. So, but the page number 24 of the deputation.
When did he retire?
Worship, the date of retirement.
31st December 2017.
17. He retired in 17.
Yes, and then, but the DP started before that.
You accepted it, let him off with a warning. That DP was closed.
After that, Lordship, there is another order where it is says that Lordship, fresh DP,
Fresh.
yes, but a sanction has been accorded
Fresh.
to issue DP.
Fresh. Continuation cannot be. Cannot be. If you have to issue a fresh, then it is the only sanction of the governor.
That is that's what the loss. I'm not Lordship, Lordship, I think I think to pour some more light upon the Lordship, let me get the record, Lordship. It will, I think,
Get the record.
because without the records, it will be hard for me to
Right, you get record.
And secondly, in regard to that, Lordship, non-releasing of this provisional pension. Lordship, it has been stated in how this is that during that period, Lordship, there were some financial irregularities, and we could not recover the amount of something 8 lakhs for 8,40,000. That is their Lordship. Accordingly, the step has been taken that we have stopped, but otherwise, DCRS and contribution, everything has been paid as part of scheme and everything. So, Lordship, at this stage, also, I may be allowed to get a record and it allowed to pass it for this court. Lordship, after that, Lordship may decide what is to be done.
Here from 2023, the repetition was filed. The provisional pension has, they have objected to the provisional pension saying it's either a record.
That it is not covered under Rule 21.
Yes, firstly.
Part by 21B.
Firstly.
Now, if that be so, provisional pension needs to be released under 22.
22.
Under what circumstances? When the proceeding was initiated under 21.
Only under 21. Otherwise, my provisional pension.
21.
Yes.
Or a TP has been continued.
Yes.
Only then.
Only then. My final pension is not also being paid. Nothing is being done to me.
That is something we look in. That your claim for provisional pension,
yes,
when you accept it is under 21.
No, I am saying that even if it is under 21, even if we assume it is under 21, yet they cannot stop my provisional pension.
Except it is under 21, no. Directive to reduce the provisional pension.
I will not accept it is under 21 because it could not have been under 21 until the time they finalize it.
So therefore,
even
it is not under 21.
Then otherwise I am entitled because they have not finalized it.
That otherwise we will examine, but 22 is not applicable, either or. 22 comes only if 21 is applicable.
When 20, then Lordship would decide that 21 is not applicable.
So we'll decide it.
I remain without any pension, my lord.
What can be done? You are asking for provisional pension under 22.
No, I am showing that even if it is under 21, if it is there, yet I am
Therefore,
entitled.
provisional pension. Otherwise, you are entitled to full and final pension.
Till they decided I am entitled to a provisional pension.
If 21 is not applicable,
my lord,
or if any order has been passed under purportedly under 21,
yeah,
and it's contrary to the provisions under 21, then there is no question of proceedings under initiated. Prima facie, there is no sanction of the government.
No.
So, prima facie, it is not a continuation of the proceedings.
Admitted position is there is no sanction of the governor.
Right. So, sanction is not
in their affidavit. It's admitted.
It is not a continuation of a proceeding initiated earlier.
No. Again, in the affidavit, they say this is an initiation of a fresh proceeding.
That's right. So, therefore, 21 is not applicable.
21 is
21 is not applicable. Your claim for provisional pension under 22.
If prima facie there is nothing against me, then my lord,
you are entitled to full and final pension.
Till they finalize it, I am entitled at least to a provision. I need to survive, my lord.
If you want to
2017 to 2025, 8 years without a provisional pension.
Yes.
Mr. Lordship, Lordship is allowing is Lordship allowing that provisional pension, then in that regard, I think Lordship may consider this instruction, Lordship. I think Lordship should go through it once.
What instruction?
Basically, what is said that Lordship, prior to release of all pensionary benefits, no liability certificate needs to be submitted against the retiree Pradip Chandra Bora was retiring from the Nazrat branch as the cashier. Non-realization of Bakiza collection of 8.40 lakhs by Trio so was reported during his tenure in the letter from the Assistant Audit Officer, Office of the Accountant General. However, the exact amount of liabilities in respect of Sri Pradip Bora, retired senior assistant cum cashier pertaining to Nazrat branch, would not be ascertained due to anomalies in records maintained by him. Hence, the question of provisional pension does not arise. There is another letter of data 2024 from DC Nagaon to the special officer of the Honorable Governor Lordship. Here in one of the paragraph, it has been stated that now in compliance to the order issued by so-and-so on 10/1/2024, the report submitted by the inquiry officer on 21/6/24, after scrutiny of records such as receipt book, cash book, payment register, etc., revealed financial irregularities amounting to rupees 17 lakhs 63,589 during the tenure of Sri Pradip Chandra Bora as cashier between the period 2015 to 2017. These are some facts.
You may like to go through this judgment, if it has any relation. We'll have it on 30. Get your records. List on 30. May. Permitting the council for the state respondents to call for the relevant records. Enabling him to complete instructions by calling for the necessary record. Mr. T. Bhattacharya, for accountant. List on 30. You may go through this order, I don't know, may or may not be. I'll go through. Hey, cool.
Please, Your Lordship. The petitioner approached this honorable court regarding the appointment, challenging the appointment of the private respondent number 6 as Anganwadi worker of number 2 Khoirabari Anganwadi Center. Now the private respondent has raised an objection that I am not a local person of the area. In her affidavit, Lordship, at page.
Who will decide on this?
That is what, Lordship. The deputy commissioner, district commissioner will decide, Lordship, whether I am the resident or she is the resident.
Basically, Lordship, the district commissioner can decide it.
Yes.
Can decide.
He can decide.
Who represents district commission?
The district commissioner, Lordship, respondent number 2.
Counsel for the parties, the petitioner before the court putting challenge the appointment of the private respondent as Anganwadi worker.
Yes, Lordship, Anganwadi worker of
in
number 2 Khoirabari Anganwadi Center.
Khoirabari Anganwadi Center in the district of Tamulpur.
Tamil.
The private respondent in its turn has filed an affidavit raising the claim that the petitioner is not permanent resident of the local area in which the Anganwadi center is situated, and therefore has no right to claim for or assail the appointment, claim for the post or assail the appointment of the petitioner state post. Under such circumstances, the deputy commissioner
Respondent number 5.
Respondent 5 will conduct an inquiry and submit a report as whether the petitioner End of the order, the respondent number 6 are residents of the local area in which the so and so town Anganwadi center situated. Let this report be placed before the court in weeks by way of an affidavit. But you first bring that report within 2 weeks. So, copy of this order be marked to the office of the senior government advocate for onward proceeding. Senior government advocate Assam. Placed accordingly. Mr. Or for petition, Mr. P. Chaudhary for respondent, state respondent, PTC. Mr. C.K.S. Burua for state respondent. Anyone for private respondent?
It was there. It was there. That's why I am.
Yeah.
May please your lordship, my lord. This is similar header number 45, my lord. They have not communicated the ACR, my lord. Petitioner is not given promotion according to his seniority. In their affidavit, they have admitted that it is not communicated.
You are a member of Assam Rifle.
Yes, my
So it is when is the other matter fixed?
same. Assam Rifle.
When was it fixed?
Same date may be given,
All right.
45 and 49.
This is item
49.
49. This matter on so and so date as item 45.
Along with 45.
Mr. Not along with, on the same day. They are
Same
not
day.
connected.
Same.
Huh?
Same day.
Same day, yes. Mr. P. Chakraborty, let's see. Yes.
Right.
The petitioners herein are appointed in the Home Guard services of the state and seeking pay parity at the Assam Police Service Junior Grade. The exchange of pleadings have already completed. Lordship may pick it for a hearing. My lord.
Yes, madam. Both minor finance and the home and court together find that.
I heard counsel for the party. The pleadings are complete, it's approved. Matter be listed for hearing.
Well, after 2 weeks,
In August,
can it be?
after reopening, July. Let it be in July.
But can it be on June?
Pay parity, you are asking for pay parity. You are in service. You are asking for pay parity. There is no urgency here. Yes.
Okay. So Lordship, is the claim for pensionary benefit of my deceased father, your Lordship. The petitioner number 2 and he is the minor daughter of the deceased Lordship, who was the government employee Lord.
Minor daughter.
Minor daughter, petitioner number 2 and 3 and 4 are the son of the deceased. Out of the marriage, out of the second wife, Lord. So Lordship,
No, petitioner, who is the petitioner?
petitioner number 1 is the mother of wife of the victim, second wife. So she is very much
Second
clear that she is not entitled to get the pensionary benefit, but she did not claim. Whatever may be, the petitioner number 2 and 3 is the minor daughter of the incumbent government employee who died, Lordship, and petitioner number 4 is the son of the incumbent, Lord.
What happened to the first wife?
First wife has already withdrawn as per the affidavit submitted by the respondent authority commissioner of police administrative. That is came to my knowledge that the first wife has already withdrawn the entire pensionary benefit as well as the retirement benefit, almost 39 lakhs 40 rupees, Lord. And thereafter, Lordship, the first wife has receiving the pensionary benefit without the knowledge of me, Lordship. But at the time of Lordship submission of the document, Lordship, the first wife and the counsel for the first wife has asking me to submit some relevant document pertaining to the minor daughter as well as my son, Lordship. I have submitted. Then thereafter, Lordship, there is a fraud, Lordship. In the more particularly respondent number 9, that is the private respondent who is the first wife, Lord. without my knowledge, Lordship, without knowing any intimation to me, Lordship, they have
The
already receiving entitlement.
petitioners 2, 3, and 4 are children born out of between
Second one, second one,
second one.
second one. 2, 3, and 4, Lordship. And 2 and 3 are the minor, Lordship, at the time of death of the deceased incumbent, Lordship. Then 4 is the son who has already attained the 18 years, Lord. So what, and he is also entitled to get the other retirement benefit. Therefore, I have inclusion his name as a petitioner number 4. So, Lordship, there is a
Who is for the
Lord-
private respondent?
Definitely it is necessary, but Lordship, the affidavit filed by the respondent, Commissioner of Police Administrative, wherein stated that the entire amount 39 lakhs 40 rupees has been sanctioned in favor of the second wife, first wife, Lordship. So, Lordship, maybe the at the time of
Has the
sanction,
amount been released? Amount released?
Yes, Lordship, it's a long back, Lordship.
but Lord, no longer, just this is the case for the in the year of 2022, Lord. So authorities should have to examine, Lordship, that prior to release the pensionary benefit, Lordship. Now they have filed an affidavit. This is not an appropriate format, your Lordship. They should be filed the annexing, affixing with the record, Lordship. NOK is the must necessary at the time of filing, at the time of disbursal of the pensionary benefit to the in favor of the first wife, Lordship. If the NOK has been submit that the same has been obtained fraud, Lordship, it will be crystal clear only upon call upon the entire document, Lordship. So call for record, Lordship. So if there is a fraud, Lordship, there is a definite, Lordship, pensionary benefit should be immediately held up, Lordship. Only now, only interference of this Honorable High Court, Lordship, maybe, Lordship, 50% pensionary benefit already been held up, Lord. I don't know whatever it is executed or not, Lordship, but I have duly communicated to the respondent authority, Lordship, by finding a proper representation in a proper format, affixing with the Honorable Court order, Lordship, intimated the authority, Lordship, when asking and requested to held up the 50% salary, Lordship. That is the order, Honorable Court order itself, Lordship.
So it is being held up. Is it held up?
50% has been held up, Lordship. But, Lordship, can we call for the entire record, Lordship? So NOK should be required, Lordship. If NOK has been obtained by making fraud, Lordship, the entire pensionary benefit has been held up.
Have you taken steps on the private respondent?
Yes, Lordship. I have taken a step to the private respondent and implemented as a respondent number 9, Lordship.
Yes. What do you say?
So this is not the fair submission, Lordship. Previous date, Lordship, they have taken time, Lordship.
Who is your senior? Who is your senior?
No. Your Lordship order itself reflected, Lordship.
Our order reflects you did not appear.
No, Lordship. That's previous order, Lordship, Honorable Justice Sumon Chiam, Lordship, and I have paid, Lordship. And Lordship,
Subsequently,
yes,
there is one
yes.
more order where you did not appear. Anyway, well, you have, but he's raised an issue that whether the next of kin was properly examined or verified to find out on what basis.
Lordship, now this is between the Accountant General and the Finance Department, Lord.
No, but who forwarded the papers?
Yes, Lord. Papers have been forwarded by us, Lordship, and it is written in our affidavit.
So you have, but
Yes. Lordship, we have categorically stated, Lordship, that so-and-so who expired on 23/21 while in service and
respondent 5
thereafter.
affidavit.
Yes, Lordship.
But this is not in a detailed format, Lordship. They had only submitted that 39 lakh that has been sanctioned in favor of the first wife. Then thereafter, this is not the fair submission, Lordship. And this is also only written, Lordship, and submit some document, Lordship, but NOK must needed, Lordship. The authority should have been examined at the time of disbursal of the pensionary benefit, Lordship, in favor of the first wife.
Lordship, one thing, almost 6 months we have filed our affidavit, but till date, no reply, no rebut of the affidavit, Lord.
There is a distinctively clear no more required, Lordship. Those so, Lordship, call for records and NOK, Lordship, whether NOK has been submitted or not.
What records you want?
So Lordship, NOK Lordship, at the time of submission of the disbursal of the family pension Lordship, whether petitioner respondent number
But,
9 Lordship has
respondent nine
submitted
you
NOK or
filed.
not.
Have you filed your affidavit? Do you produce the next of kin certificate?
Yes. Yes.
You produce it. Not time being, we give you 2 weeks time to file it. File it. Next of kin certificate. Heard Mr. M. Soikia, counsel to the petitioner, MSF Bhattacharya, learned government advocate, and Mr. B. Borgonai, learned counsel to the private respondent number 9. The dispute between the petitioner and the private respondent 9 with regard to pension, any benefits of late. What is the name of the person? Govind Chandra Bose, who died in harness while serving as a Havildar in Brigade AB, the office of the Commissioner of Police, Patna. Petitioners claim to be the second wife and the children born out of the marriage of the petitioner of the second wife and late Govind Bose, who claim that they are entitled to a share of the pensionary and other retirement benefits of late Govind Chandra Bose. So, however, private respondent 9, who claims to be the first wife, has claimed has staked her claim for pension in exclusion to the repetition. Earlier by passed by court and dated 10/6/2024, 50% was directed that the Treasury Officer Kapur Guwahati shall withhold disbursement of 50% of pensionary benefit of late Govind Chandra Bose, which is currently being disbursed to the respondent number 9. Since the pleadings are complete, have been listed again after 2 weeks, and also permitting the respondent number 9 to bring on record the next of kin certificate, which they claim they had relied on before the concerned authorities at the time of claim of their pension. Yes.
One thing that I want to, this order of pensionary benefits lordship, it was passed in 10/6/24. But as per our affidavit lordship, it was disbursed prior to that.
You should have filed an application saying that this order should be modified. You should bring it to the notice of the court, at least after 2 weeks.
I am deeply appalled.
May please the lordship. Not the respondent number 5 has filed an affidavit, madam. I'll tell the grant me 2 weeks time, I'll tell the reply, madam. And there is an interim order also, madam. And regarding the madam, the provisional pension, madam, they have not done
You
anything.
file your counter.
Madam.
Mr. SP asked for the petition for 2 weeks time to file counter affidavit. Rejoinder affidavit, the affidavit with the state. Prayer made is allowed after 2 weeks. Interim order passed earlier will continue the next date. It's on 21st. Mr. B. Gogoi for
the respondent.
for the respondent. Mr. A. Boro. R. Boro for the accountant.
Please, your lordship. Herein an affidavit has been filed by the Transformation and Development Department. My lord, the affidavit of the Health Department would be necessary because it is their notification that we are challenging.
Yes, help.
Lordship, seek for 2 weeks further time. Lordship.
But this letter may come up on 5th, my lord. There is a series that, my lord, disable certificate was issued. Subsequently, after appointment, a committee was constituted, examined, and it was found that they are not disabled candidate. They are below 40%. The series is coming up on 5th. Same issue. Here, the certificate has finally been cancelled. Let it be on 5th. In the meantime, we'll file a on behalf of the director.
Has submitted by the government, but not 5th of June.
5th of June.
5th of June. As similar other matters are stated are stated fixed. It's a
Much of late.
here. Here.
My lord. I referring
Certificate is found to be invalid, not correct.
My lord, that true, my lord. Earlier report is, my lord. Earlier occasion also, my lord. This the coordinate bench of this honorable court take note into this of the annexure 1, my lord. Certificate, my lord. Then only, my lord, that order was passed, my lord. But my lord, there is other document, my lord, which were.
But why should we even allow you to proceed in a matter where you have enclosed a false certificate?
My lord, these documents was provided by her husband, my lord. When he was alive, my
Well, provided by the husband, you should have found out the
lord,
particular.
she has no knowledge, my lord. She has bona fide belief on her husband.
You are now before the court. You can't claim that ignorance. It was given to by somebody. You are relying on a document.
Yes, my lord.
You have to be certain that this is an authentic document. And when there is an affidavit file, you are not taking any steps.
My lord, I will file, my lord.
To either correct it or withdraw it or do whatever you want to.
And I will take inspection.
Mr. Sikdar, you were supposed to give the proportion as per the earlier order. 212, 2022.
My lord, supposed to pay my lord daughter. But daughter is already married. He has a husband. My lord, now he being married and major not liable to pay.
You are the second wife.
Yes, my lord.
And according to
He is claiming second wife. He is not a wife. I am the second wife. My husband married one.
Then why are you saying that the daughter is not entitled? Daughter is married.
My lord.
If you don't accept her as wife, how will you accept?
My lord, my submission is that the petitioner might have some illicit relationship, extramarital relationship with my husband, and out of that, his daughter may born my lord. My lord, I admit our claim. The daughter is to maintain it. He is not married. But since now married, my lord, our claim has gone, and he has no lucas to claim. Daughter has the lucas.
You are accepting that there was some relationship.
Yes, some relation, extramarital relationship. Never married.
Never married.
Never
No certificate.
Yes.
But some relationship.
Right.
Now, during the lifetime of your husband, did you take any step, confront him, and take
My lord,
necessary
during
action?
lifetime, my lord,
You did not.
there is no record to show that this lady is the wife of my husband. No record.
This is
Never.
this is the contrary submission you are making. On one hand, you are saying there could be some relationship, which means you or you suspected.
My lord, some relationship, extramarital relationship, and as a status as a wife, there is a difference, my lord.
Maybe, but under the provisions of the erstwhile CRPC as well as under the new act, there is a provision for maintenance on the husband, no doubt. But this amount you are getting is not is an amount which is not a part of your property.
My lord, admittedly, my lord,
where you accept
it is, I am,
where you accept that there was some relationship and a daughter may have been born.
my lord,
You are entitled to.
My lord, I have obligation to look after the daughter of my husband, but not my lord, the lady who has the.
There is a full-page judgment saying that first wife, second wife, third wife.
My lord, let him show any valid marriage documents. My lord. Let him show any valid marriage documents. My lord, my husband has made an affidavit that all claims, I am the only wife, and that has been entered in the service record. I am not only saying on the my lord affidavit, but that fact has been
If
recorded.
your husband was alive, then would she have a claim against your husband or not?
My lord,
Even if he was not married, assuming that
My lord,
some relationship.
that was not known to me. After filing of this petition, some
No, we are
records.
asking you divorce the fact. We are asking you that under law, if there was some relationship with the wife, with the petitioner, would she be entitled to claim for maintenance?
My lord, some relationship was there, and the record shows that this petition, the annexer shows that uh, that relationship has, out of that relationship, some amount has been already paid, my lord, during the lifetime of 1,30,000 has been paid, and out of that, my lord, he is to forgo all claims. May have some extramarital relationship. That I am saying on the basis of that record, but no marriage documents.
Yes.
My lord, immediately, my lord, there is no marriage document.
In view of a statement made categorically that certificate is not correct.
Hmm.
Why do we even go beyond? To discuss it right here.
Tell my lord, may allow me to with liberty, my
Hmm.
lord, may allow to this petition with liberty.
No liberty on this.
My lord, I will approach the civil court, my lord, annexer.
Yes.
Lord,
In view of the government, made the affidavit by the state that the certificate enclosed by the petitioner had annexure 1 between the of the of the who issued this certificate? Registrar of the Muslim Marriage and Divorces, Registrar and Qazi Primary, certifying that the petitioner and it Saleh, what is that? Saleman.
No.
What is the name of the husband? Saleman.
Suleiman.
OLEMA.
Suleiman.
Yes,
Suleiman Khandekar were married, and the marriage was solemnized on 2003-1995. Could not be verified. Concerned operative. With prima facie raises the question as to the council, after submitting at some length to the court, the liberty of the court, withdraw the petition and pursue his remedy before an appropriate forum, namely the Supreme Court. In view of such prayers made without expressing anything on merit, the petition stands dismissed with liberty to the petitioner to have competent pursue his claim. The declare for respondent number
7.
404, Dharma 4, 1, 5. Let petition dismiss in order to any step against petty higher.
Deep level. Let's yeah, please. In this case, regarding method pertains to pension, non-terminal pension, the department has filed an affidavit. Finance department affidavit is very much necessary because we have challenge and close lordship at page number.
They have challenged the
56.
decision of finance department.
Case number 56, my lord, or past service is not counted.
Finance is a party.
Yes, lordship.
In extra I, page 55, they have challenged. It is taken by the finance department.
Third counsel for the party. Challenge made. Application number 22 dated 6/7/2017. Page number 55. Stand of the finance department. Let's say. Stop affidavit has been filed. Accordingly, finance department. Make of it. File affidavit in opposition.
Time for 120.
Get a copy of this order. Wait. Your name?
You
After
may prefer that.
after 3.
Level.
Lordship, I seek a day's accommodation, Lordship, to file the affidavit.
There's nobody for the petitioner.
Petitioner,
MS N Bhattacharya, wait for a week's time, further week's time, but yeah. The matter clear enough. It's up to one.
Yeah.
Lordship, petitioner is the surviving third wife, Lordship. Let.
The inquiry, some inquiry was to be done.
Yes, yes, Lordship.
The last week, Doctor has pointed out that from the army, there is a communication to the district commissioner. For the district commissioner can act upon the basis of that.
Yes, Mr. Tom, Purva. No, he's an army man, whether he's, which wife is from which district, whether the claim made is genuine or not. No, no. Mr. So-and-so appears for the petitioner, Mr. H.P. Chaudhary for.
Lordship,
You are
one
from the
thing-
CGC.
I'm
CGC.
Yes.
In this case, next of kin certificate is holding the field.
Hmm?
Next of kin certificate is holding the field.
Let him examine it.
Yes, sir.
Representing the respondents number 1, 2, 3, 4, 6, and Mr. C.K.S. Borua appearing for respondent number 5. Stop Mr. Borua. 6. Liberty of the court to complete instruction and breathe for 3 weeks' time. Therefore, it's down. You are appearing in this matter?